Make a mention, madam. I don't to make a mention, madam. Well, decision number 136 of 23. Petitioner is in custody since 11/11/2020. I
The criminal appeal which I had mentioned last week, my lord, that widow is my lord, unable to sustain the livelihood of the minor children. So till that it is
Will include it now. Get ready.
And another matter, my lord, criminal dismissal was in the list last week, my lord. It could not reach, my lord. Because your lordship
In this bench
before
could not reach.
last week.
So I told you this week.
Right.
We'll see.
Friday.
Rarely that happens, but I try to exhaust the vote, but still.
Your lordship said that it will be taken up next week.
Next week, but I don't know. It will be taken up this week.
I beg your pardon, Your Lordship. So, criminal division, Your Lordship. Here, our discharge petition has been rejected by lower court, and they are framing this is pending for framing of charges, Your Lordship.
Let's see.
It was before the.
We'll see. Yes. Yes. Start.
My lord, I may be permitted to mention CRL 837/23, the bail application. Criminal
Give the memo if you have. Anybody is there in the court who can give a memo?
Yes, my lord.
Please give the memo. We'll see. Huh? Okay. Yes. Any mention?
I beg your lordship, sir. Item 33.
He'll call every page wise. Give the memo. Yes.
Hearing.
Yes. We'll see.
Particular.
Huh?
Weekly hearing if possible.
If possible, let us see. Today is, I think, how many matters?
So
100 matters. Let us see if I can. If I can, I'll discuss it. Let us see 100 matters. If right cooperation comes from that side, I can dispose it up. No problem. We'll see. Let us see. Yes.
Any mention from supplementary list item 1 to 5?
My lord, item number 3, my lord. I mean BC, my lord.
Yes.
My lord, I am praying for an urgent call taken up next week, any date, my lord.
No. Is there any interim order?
No, my lord.
Okay. Urgent. September. Yes.
My lord, can taken up on Monday, my lord, due to some.
No, September. Once it is listed, if you are asking adjournment, it will go to September. No further argument. Yes.
My lord,
No, September. Yes. 6 to?
6 to 9.
Yes. This is?
10 to
proceeding.
Okay.
10 to 17. 18 to 23. Item 24 to 29. 30 to 35.
Item 33. Jaswant will appear in this case. I may prefer 11 or 12, my lord. Will concentrate.
What do you, this is for bail?
My lord.
How much you have undergone?
So more than 7 years.
What is the sentence?
20 years, my lord.
20.
It is both okay.
September, first week. Yes.
Lord, may I prefer 11 or 12?
No. You can't decide. See, I have to set my
Yes, ma'am.
list, So once you are there, you argue, I will hear it. Otherwise, it will go to September. Because
I have
everything
instructed
gets-
Mr. Jaswant will appear in this case for that reason.
It's all right. September first week. Yes.
36 to 39. 40 to 45. 46 to 48. 49 to 53. 54 to 58. 59 to 63. 64 to 69. 70 to 73. 74 to 80. 81 to 86. 87 to 90.
87, pardon to your lordship, seek an adjournment. I'm for the OP in this case.
Is there any interim order?
Interim order, I have also informed the petitioner.
It's operating against you.
Against you.
Of September first week.
Next week, when
Council President respond. Yes.
91 to 96.
My lord.
97.
I may be
Yes.
pardoned, my lord. Item 96 on behalf of
Yes.
Mr. Manas Mahapatra Dinapur will be taken up next Monday, my lord.
No. What is this matter?
My lord, I am challenging the FIR again in 498 AM.
Is there any stay operating?
No stay, my lord.
September. Yes. Yes.
97 to 100. Item 1.
What is he asking?
145 proceeding, 2011 matter.
145, 2011. Pass your dispute.
In a 90, once it was challenged in the year 90, it was remanded.
Hmm.
After that, again, that order improved 30 is under challenge.
Okay, it pass over, I'll dispose it up. Okay. Pass over, yes.
Item 2.
Pass over, okay.
Item 3.
3
Three
Three adjourned.
Yes.
Item 4.
Legal aid brief. JCRL. Out of 1912.
Nobody is appointed?
From Mandakini Panda name is reflecting there.
Mandakini Panda has been appointed. Her name is there?
Name is there, man.
And she has filed yes, she has filed.
Engaged through legal records.
Pursuant to the order dated 19/12/24, Mandakini Panda has been appointed as an anarchist to appear for the appellant. However, she is not present today. In the interest of justice, sentence to. What is the sentence?
The POCSO, nothing is with me. Only one bail application is there. She has filed a bail application.
POCSO is also there.
POCSO is there.
Issue notice.
Issue notice. She has bail application filed. I will convey to him from there.
September 11, September 2nd week. Yes.
Item 5.
Serve the notice on the complaint. Yes. 5 years. 5.
And the JCRL matter. There are two notice. Fresh prisoner's petition on 16/1/2026 has been received. Noting that. 16/1/2026. Fresh Vakalata Rajiv Bihari Mishra.
Yes. Rajiv
Bihari Mishra.
Bihari Mishra. Whose name is that?
Rajiv Bihari.
Rajiv Bihari Mishra. It is allowed or what?
His name
Vakalatnama
is
5. Let's see. Rajiv Bihari. Vakalatnama has also been filed. Yes. Pursuant to the prisoner petition dated 15/1/2026, Mr. Rajiv Bihari Mishra has already filed Vakalatnama on behalf of the appellant. However, today he is not present in court. What is the offense?
That file is not the only application.
10 years.
The
NDPS.
the brief
The interest of justice. Information. Rajiv, his name is there.
20 years.
Information. Yes. Second week. Yes.
Item 6.
6 also.
Yes, madam.
376 to 1.
Yes.
10 years of conviction, Australia has 21 since 2023 and 74 years old.
24 years.
Yes.
You are not covered by that scheme.
NALSA.
NALSA guidelines.
Hey, that's in some offenses, the POSCO 376 model that are.
POCSO is also there. Okay,
Some of offenses are excluded from that.
Excluded from, yes. Okay, call for the report. The report second. I'm calling for the custody certificates and all.
Sorry, my lord, item number 5, my lord. Item number 5, my lord, sorry.
5 you didn't come?
Lead to other problem, my lord, sorry.
Huh? What do you want?
My lord, prisoner petition is there, that should be accepted. And admission, my lord.
It is already accepted. You have already.
20B2C, my lord, 10 years conviction. I for bail and stay.
What is the period undergone?
Probably 5 years, my lord.
Probably. All the 3 years. Yes.
Item 7.
I'll obtain this. Yes.
That a brief copy, brief names.
Give the copy, give the copy if you have.
Legal copy.
Do you have a copy, extra copy?
Yes.
Give it, give it, yes. 7.
My lord, item 7 may I please your lordship. My lord, substantive sentence imposed 5 years rigorous imprisonment under section 376 read with 511.
Yes.
Allegation committing attempt.
How much
to
you have
commit rape.
undergone?
My lord,
Undergone period?
in the meantime, 10 months already in custody.
Only
This is more than 62 years aged, my lord.
Jail conduct. Appeal certificate. Second week. Yes.
My lord, bail.
No. Jail conduct and you get the 3 certificate.
My lord,
Antecedent also and custody certificate. Yes. Next 8.
obliged.
Item 8.
If possible, that will be taken up. If possible, that too, I don't know who pass over. If so, impossible.
Okay. Item 2. Yes. Item 2. Yes. Yes.
The last order. Dated 25/7/23.
25. 7.
25/7/23.
Yes.
The FIR is of 2025. Today, cognizance is not there.
Yes. What is happening? The charge sheet was filed in 2015. What happened?
But the affidavit is as per the order of this Honorable.
13 years has been left. Since the registration of the
Affidavit
case.
has
Nothing
been
is
filed.
happening.
In the meantime, the sanction has been obtained and the supplementary charge sheet has been filed.
When?
That is on appeal 25/2023.
No, you have filed the charge sheet on 29/7/2015.
15. By that date, sanction was not obtained.
Without sanction. When you got sanction?
Cognizance was that para 4 the affidavit.
Affidavit.
Following the obtaining sanction order, prosecute the accused person and after receipt of the sanction order from the company authority, Collector of Balangir, supplementary charge sheet has been filed on 25/2023.
Thereafter, what happened?
Thereafter, I have taken instruction.
Even then, it is more than 3 years. FIR is of 2010. There should be some limit to all this thing.
Next week, I will take that affidavit as I have.
2010 FIR, first charge sheet filed in 2015 without sanction, and you got the sanction another 5-6 years, 8 years. Thereafter, file a supplementary charge sheet obtaining this thing, and thereafter again about 3 years, more than 3 years. There should be some limit to. You file a detailed affidavit, I'll pass.
Next week, I will satisfy that. Without sanction, even if the charge sheet filed in cognizance, it is not bad into.
Additional affidavit. Explaining the cause of delay. Explaining the cause of delay, filing the supplementary charge sheet, and in view of the fact that the FIR was registered on 4/2/2015, and the charge sheet was initially filed on 29/2/2015. As per the affidavit filed by the state, it appears that on 25/8/2023, the supplementary charge sheet has been filed. Even after lapse of 3 years, it appears that cognizance of the offence has not been taken. In view of this, that the state council filed a additional affidavit and explain the.
Pardon me, Lord, my lord. Item 4 पे admit ही नहीं था तेरे notice जीवो information. Pokso था 3766 376.
Notice है नहीं.
No, Lord. Admit भी है नहीं.
Delay, how much delay?
Delay कितना?
Delay, how much?
इसलिए plan delay.
Okay, anyway, delay करना. Delay करना. Admit. This one of the offenses also. Notice, no, call for TPR. Yes. Yes.
Item
8.
Item 4 3 copies so that we can take instance.
Three
Item
copy.
3 copy.
8 may I please, Lordship? The petitioners have been convicted under section 325 and 34 of IPC, my lord, and had been directed to
324.
325 and 34, my lord,
Yes.
and been directed to undergo simple imprisonment for the period of 2 years, my lord.
How much you undergone?
15 days, my lord. So we were on bail, my lord.
All for the custody petition. Yes. These
Item 9.
second week, yes.
Record call करना.
His conduct is more important. 325.
Yes.
Yes.
POCSO 6 and 4 is there. Appellant is the husband of the informant. The notice may be issued.
Yes. Sorry, you are appearing for?
Appearing for the appellant.
Appellant. Yes. What do you want?
Your lordship, POSCO is there. Notice may be issued.
Okay. And I, yeah. It has already been admitted. It's
No,
not even admitted.
not admin.
Not admitted. Admit for it. Admit for notice for it. 140. Yes. Please sit after the service is complete. Yes.
Item 10.
One of the offenses also POCSO.
So finish it. Notice. 10. Yes. Not yet admitted. Not yet admitted. What is the offense? Well, she is.
Male or female?
You are appearing?
Male.
Yes. What is?
Confident
POCSO is there.
POCSO is there.
Notice and realization of a fine state. Yes, next.
Item 11.
Appellant has been convicted under section 7 of the PC Act. On
Rap case.
3 years RI and 20,000.
Sentence is 3 years.
3 years and fine of rupees 20,000 in default 4 months RI. He was all through the trial. He was bail.
How much you have undergone?
My lord.
You are there in custody?
No,
Are
no,
you there in
the
custody?
trial court has given
389.
death,
3.
yes.
389. 389 was granted while sentencing and accordingly sentence one is released on bail. Yes.
stay realization.
Yes.
Obliged.
Stay realization of.
Item 12.
Yes.
Item 12 is in custody since 23/7/26 because of sentence of 4 years. He was all along on bail during the trial.
Impugn order is on when July 26.
23 laws.
July 26. 23rd July 26. He is in custody.
Yes, he is in custody from the date of judgment.
Are you opposing or?
No.
No.
He was all along on bail. Why? Liberty should be given to him to
Sentence for 4 years.
place his matter.
And since 4 years sentence was granted, he was taken into custody on 23/7/2026. Since then, he is in custody. And now throughout the trial, the appellant was on bail. Regarding it to the period of custody and the short sentence of 4 years imposed against remains suspended. Yes.
Item 13.
Item 13, 6 months and 1 year RI. 2 petitions, IAs have been filed, one for suspension of sentence, another for bail. Suspension of, unless sentence is suspended, bail cannot be granted. So this bail copy has not been given to me.
It's all like 6 months, na? Sentence.
6 months and 1 year, respectively.
Okay.
So
Your Lordship, humbly present interim bail is expiring on 11. May I kindly consider?
IA copy, bail copy may be given to me.
It's all like.
You already solved, Your Lordship.
No, no.
I have the receipt, Your Lordship.
Okay, 6 months.
This is suspension of sentence.
No,
This copy,
Yes. 1966. Receipt.
How is in custody? 6 months?
No, 6 months he is not.
No.
He is on bail.
Your Lordship.
He is outside.
Then
No, only copy has not
Copy
been.
is served, Your
2
Lordship.
applications have been filed.
Receipt.
One is for suspension of sentence.
Sentence also. The petitioner is having the benefit of 389(3). The petitioner on any bail. Suspension has been allowed, and free can be granted bail.
Bail granted, fine stayed.
Fine state, yes.
Hon'Ble.
14.
Simple imprisonment for 3 years. And 1 lakh fine.
1 lakh fine. Okay. Yeah.
disproportionate assets case.
Suspend sentence. Yes. Yes.
15.
My lord, 4 years punishment and
Sorry.
4 years custody, 30
Offense.
30 from the date of judgment.
Offense.
Offense 7 PC Act.
7.
7 offense 7 PC.
No, code. 15 copy has not been served. Let them serve the copy.
Give the copy.
Well, copy of
No
Give
copy has
copy.
been served and registry may be directed to indicate vigilance in the cause list. No copy has been served on us. Let them serve the copy. Let it come next week. Next week.
Monday. Monday.
All along bail.
It's all right. Monday you give the copy. Monday I am taking up.
My lord,
4-year sentence, sir. If you want, I can reject also. But I am going to give you wait for 2-3 days. Remain there.
my lord, tomorrow, today, in course of day, serve tomorrow.
Next week.
all along.
You
bail.
should have be careful about it.
I pray that registry may be directed to indicate all the vigilance cases as vigilance in the bracket.
Easy.
My lord, in course of day, I will supply
That's the
copy.
reason they are supplying the copy to the state and all this. Okay, we'll see. Yes, next.
16.
Pass over. Okay.
Submit one thing. Item 16, let it come after lunch. It's for final disposal.
Pass over after.
I'm ready, my lords.
It will come after lunch only. Yes. 17.
Item 17.
Lordship.
The 17, the copy may be given to me. No copy has been solved.
The petitioners are the
What
son
is this matter is?
My lord, the petitioners before your lordship was the father is the accused in a disproportionate asset case. They are the son and daughter. Their bank accounts freeze, my lord. And since 2023, their bank accounts freeze. They are
Give a copy, then he should have some idea. 2026.
But how they file it?
At least it next week. Give a
Copy
copy.
should
Apply the
indicate
copy.
when-
At least it next week. Yes.
Monday.
Yes. We give a date next week anytime. Yes.
18.
Please, your lordship. In this case, the petitioner has filed this writ petition to transfer this consumer case, which is pending before the district commissioner Baleswar. Due to non-functional of district commissioner Baleswar, the present petition of the petitioner has not been properly adjudicated, and the vehicle of the petitioner has been seized illegally by the opposite party number 2, and which is detained in the stockyard, which is exposed to sun and rain, and the condition of the vehicle has been totally damaged.
How can I change the territorial jurisdiction? Exercising writ jurisdiction?
Because the court is not functioning, this writ
Maybe
court,
whatever may be reason.
where shall I go?
I don't know where will you go, but how can I change the territorial jurisdiction of a consumer forum by exercising writ jurisdiction?
Yes, my lord, the writ jurisdiction will be exercised, and I wonder the direction may be given.
Satisfy me, give some judgment. Can I change the territorial jurisdiction if the statute provides? Can I change the statutory provision?
My lord, due to non-functional of the court, the present petition is pending since long, and there is no chance
Okay. It's not functional. That's what you are saying. Where is that? Where have you said that it's not functional?
I have mentioned these things in para number.
Para?
My lord, para number.
Yes. Yes. Which para you have said?
Para number 10.
10.
Number.
Please read it.
That in the date of filing, there is no president and member before the district commission.
Non-functional. Yes, madam.
My lordship.
Non-functional.
Yes, my lordship.
Yes.
State consumer is there. They can file an appeal before the state consumer by
Why
section.
appeal? District forum is not functional. It is your
But
job.
they, my lordship, kindly have a glance to annexure 1. Yes, before this honorable court.
Yes.
And the order has been passed.
What
for the
is that?
settlement, my lordship. Annexure 1, page number 50.
Submit that
And the order.
party purchasing also.
Yes.
What's the operating part? Considering facts made in the petition directly
Para 6, my lordship.
by giving a reasonable amount of settlement from so as an interim measure is directed that no course action taken.
They are jumping
No,
from
no.
one.
What is this order?
This is, my lordship, the same cause of action they have filed the application before.
Where is that in the petition?
Kindly have-
That have this code opposite party to release the seized vehicle. That's a different thing.
This is also, my lordship, again they have been.
No, you are see in the earlier occasion?
Otherwise, I will take the instruction from.
No, I am only interested to know why
The district court is not functional.
not functional.
I will take the instruction, ma'am.
Get instruction
Yes, ma'am.
next week.
Yes, ma'am.
Next week. Okay. Next week.
My lord, that may be fixed.
Sarita accept notice and seek time to get instruction regarding the reason for non-functional of the district court. They should continue forward. Yes.
Oblige.
Item 19.
So far as this criminal case is concerned, in which I have intervened, I am told that this has been dismissed since 2018.
Which one?
Criminal case, out of which my intervention petition arises.
And what are you seeking in this petition?
I am seeking that it has become practically infructuous.
Cognizance.
Cognizance was taken against one Ambunath Singh because he did not comply to the direction of the industrial tribunal. He had committed that I will give employment to 153 employees when our unit will again begin. Unit began, he didn't adhere to the undertaking given.
Who are you? You are not from Samuna.
I am one of the employees, one of the persons within that 153 who are seeking job who had been retrenched.
Have you moved an application for intervention?
I had moved, but it has been dismissed, so it has become infructuous. So liberty may be given. I will work out my remedy in appropriate court if the cause of action survives.
Where is that application? Let us see. Your application is?
The contempt case initiated against this.
Which application you are talking about?
I'm talking about my application IA 1534, in which I have intervened, saying that the person who had intervened earlier to expound the cause of.
And this IA number 1534, according to you, has already been dismissed.
No. This criminal miscase has been dismissed.
The main petition has been dismissed.
Main petition.
When was it dismissed?
In the year 18, I think. Yesterday I have taken out that year, but
Stands disposed of for non-prosecution. Non-prosecution. Right on.
Another matter.
Yes.
Another person had intervened. He died. So I took over the management. His death certificate.
It's already. I need not go into all these things. I'll just give you liberty.
Only give me liberty. I will work out my remedy.
Right on. Okay. The petitioner in criminal MC, criminal miscellaneous case, 3636 of 2011 had challenged the order dated 23/11/2009, taking cognizance of offense. What are the offense? 13.
Offense not adhering to the court's mandate. Is a contempt.
Offense.
Contempt.
No.
Otherwise initiated.
What are the offenses?
Form of a criminal miscase.
Offenses.
That is case number.
Offense क्या है भाई? 30
You see CC case number 214 by
is taken under section 29 of IDA. And during the pendency of the criminal miscellaneous main petition, how it was heard on 15/1/2018 and has been dismissed for non-prosecution. In the said petition, the present applicant, the applicant number liquo, application 1534, the applicant moved intervention. Since the main petition has already been dismissed, so no intervention could be allowed. Therefore, the same is disposal. But disposal of the IA shall not include the applicants to work out their remedy under yes. Yes, next slide.
I will copy.
Item 20.
May it please your lordship, I'm appearing in the VC on behalf of Mr. Sahu. Lordship, I'm praying for a short adjournment if the registry can be directed to provide a soft copy of the brief, I'll be grateful, your lordship.
It is your brief, you have to correct. What are you seeking? Is there any stay order operating?
No, there is no interim order. There is a notice was being sent to the opposite party number 2, but as the opposite party number 2 has expired, so notice was returned back. But the opposite party number 3, it has been served.
Okay,
so regarding a cancellation of bail material.
Next.
21.
Kindly pass over. On behalf of Deputy Maharaj, kindly pass over.
Pass over. Yes.
22.
Yes.
Compromise.
What is your direction to remain present? Okay. Pass over. Yes.
23.
Same. Pass over. Yes.
24.
Yes.
24, Your Lordship, and for the petitioner, this is a disposed of case and intervention application has been moved. We have not received the copy of the petition.
In a disposed of petition, you moved application.
Your Lordship, I am for the petitioner. The interveners have moved.
What intervention they are seeking?
Your Lordship, we have not been served with a copy of the intervention petition. Your Lordship, the petition was dismissed. The CRMC petition was dismissed.
When it was dismissed?
2024.
30? 13?
30th April 2024.
April?
Yes, Your Lordship.
No. There is no such order, madam.
Your Lordship, this petition was dismissed, Your Lordship. The CRMC petition was dismissed.
No, CRMC petition, where is that order of dismissal?
22.
22?
24.
No, that day the judgment was reserved and parties were directed to file written note of submission. Thereafter, what happened?
Your Lordship, dismissed.
When? Where is that order?
It's showing in the website, Your Lordship.
Showing, but where is that order, madam? The judgment was reserved. Might be the detailed judgment might have been passed. What is the judgment is about? Where is in?
I have released.
Sorry?
Released.
It was
Your Lordship.
here it is. There is show me the order.
Your Lordship, make.
I'm checking.
But it's not here. It's not uploaded, it seems. Where is it?
I'm looking so.
Not there.
Hangs. System hangs.
Show me what was the order?
Your Lordship, this case was dismissed.
Dismissed.
Yes, Your Lordship.
That is on 20th April 2000.
12th April 2024, the hearing was done.
Yes.
30th April 2024, the order of dismissal was
And
passed.
when the application was now moved?
Your Lordship, we do not know because this has come up after 2 years and in an intervention petition we have not been received.
In a disposed of petition. the present application, that is 1894 of 20. In a disposed of petition, the present application is filed seeking intervention and certain directions, and the basis. And the council appealing for the petitioner submits that the copy of application has not been applied to her, hence she has no clue regarding the application. Let the applicant, public intervenant, supply the copy of the application to the council for the petitioner. Petitioner. This is the matter also. Second week. Second week. Okay. Huh? Approving it. No, I don't need now. Approve then. Yes. Okay, second week, huh? Second week, then the copy we supply. Yes.
25.
Yes. Yes.
Yes, fine, there is all notes on last occasion, I don't know, because the cause list doesn't show that it is on record. It is there in your lordship's.
Just recapitulate.
And just
Recapitulate. Okay.
Here the issue is the drug inspector sees certain products which he said that they were spurious from X party, let us say. And we had purchased that as a distributor from the X. So he also came to our shop or our godown and also said that these things here not to sold and they were sealed and seized. A report was made. Then on the basis of that, even though all the offenses are under the Drugs and Cosmetics Act, it has been converted to IPC and the police has filed the report before the court below. And on that basis, the cognizance has been taken and the notices have been issued. So there are two issues which I disagree your lordships with this. First is, if a special act is there which provides for the offences as well as the remedies, then can an overlapping general act be taken into aid to initiate before a court which has no jurisdiction so far as the special act is concerned? Then number two, while making such seizure and everything and while filing the complaint, when the special act specifically prohibits the police to initiate the process and continue with it, can it be continued and maintained? So these are the basically two legal issues. I'll come to the factual. Later on, if I just take your lordships.
May I pray one thing, lordship? Monday, take up at 2 p.m. I will call the drug inspector and verify. Then I will go for the minimum these two issues. I just want to call the drug inspector and then we will argue in this matter.
There is a written note. A written note of submission you have made.
If it is, because it doesn't show in the cause
Yes,
list.
it's not there.
We will file another, my lord.
You give a copy. Give a copy to. Revert it back. You come with written note of submission.
Yes, sir.
We will not waste time.
Yes, sir.
He is raising two legal issues.
Yes,
to
sir.
answer that. That's all.
Yes, sir.
Actually, whatever is there, we can go into
Yes, sir.
that.
If required,
any Monday to
Actually, I may not go into because it is at the cognizance stage. I need not go into. If legally they succeed, the 2 points, then it's well and good. Otherwise,
yes, sir.
Only the legal issue I want to consider.
Then
yes, sir.
If there is a special statute is there, can you invoke the general law and
yes, sir. That part I will do.
66 Supreme Court, it has
Yes.
been settled. my lords, and-
Any Monday 2 p.m. था वो चला कर दी.
not Monday, Tuesday? Then let it be on 17th. 17th.
7. Yes, sir.
17th. 1/7.
Yes, sir.
Then
24th.
24th. 24th.
Yes, sir.
24th. Partly heard. Partly heard. The counsels for the parties shall file a written note of submission. Submission for further hearing the matter of 24th. Yes.
Subject, let's put 2 p.m.
At 2 p.m. Yes, 2 p.m. No
Entry
problem.
order to continue.
Entry mode to continue. Yes.
26.
My lord, may I? Your Lordship, my sincere apology that
Total submission that is there.
because of the accident of my dealing assistant, the requisites could not be filed on time to the newly added opposite party number 4.
When was the notice issued?
No, my lord, the matter was
Notice was issued on?
newly added.
Could not be so.
No, when the direction was issued?
Direction was on 4/10/2024. Thereafter,
24.
the matter did not come in the list. My sincere
When the
apology.
when action taken?
Your Lordship.
When the your associate
File it, I will file.
when your associate faced the
This accident in that time only.
When?
It was not filed on time. That thereafter it was not accepted because of lapse of
when
time.
have you filed?
My lord,
Let us see when you filed.
when we approached the registry, then they denied to accept it because it's supposed to be filed within 3 working days.
Are you enjoying some interim order?
Yeah, the entire matter is civil in nature, Your Lordship.
Enjoying interim order, you don't file.
Please, nothing intentional,
process-
not all deliberate.
But
My
pro-
sincere
you
apology.
have not filed the process in 2024.
Yes, I did
enjoying the
understand.
interim order.
That's why I'm taking the responsibility.
You are taking a plea that you are one of the associates making an
No,
extent.
no,
It
that's
is
why
not so serious agent that 3
I'm
years.
suffering from fever, but still I am calm because it is my responsibility, my fault, my responsibility. I accept that.
By tomorrow
I
you file
acknowledge
it and pay cost.
Yes,
Pay
sir.
cost of
Yes, Your Lordship, please.
pay cost of 2,000 rupees, subject to paying cost of 2,000 rupees. The requisites to be filed by tomorrow.
Your Lordship, at least 2 days time will kindly be given. I'm not well.
Day after tomorrow.
Deeply obliged.
Day after tomorrow, we accept it. And,
27.
cost to be paid to the
Yes, Odisha, Bar Association.
bar association. Yes. 27.
In this case, also issued notice.
Interim order to
Interim order to continue.
Deeply
Yes.
obliged.
I have filed the requisites, my lord, but it was issued notice on register post with coding. Register post was stopped, so that notice has not been issued.
Oh, see, what is the report in the what is the
There is
report?
nothing else.
Could not be issued due to non-filing of incomplete requisition.
Incomplete.
Your lordship, thereafter there is
No. When you file?
your lordship can
Same story.
no,
same
your
story.
lordship can see the register post is stopped, your lordship.
When have you filed? You have filed incomplete. Therefore 1,000. She has not filed at all. So therefore 2,000.
I have filed, my lord,
So
but in
1,000.
register.
1,000 2 days.
Your
Fine.
lordship kindly allow me
You
to-
can't enjoy the interim order like this, sir. 2024.
Your lordship kindly speed
These
post.
tricks will not work.
Kindly allow to speed post, my lord.
No, speed for-
Otherwise, if you don't want to pay cost, I'll vacate the stay.
No, I'll
Choice
pay.
is yours.
I'll pay the cost. Your lordship kindly allow speed post.
This is a deliberate attempt, to avoid non-filing of, and enjoy the
No.
deliberately file defective this thing, incomplete process.
There is no noting that
1,000 within 2 days. Otherwise,
notice may be accepted in speed post, my lord.
Yes, speed
And
post. Huh?
I'll let the order in the register post so that.
And in both the cases, right down it's made clear that if the cost is not deposited and process is not filed within 2 days, the interim order stands vacated without notice to without
In this
further
case,
notice.
I have paid the entire amount.
Whatever, I don't know. This is I have
See,
said.
speed post-
You take interim order, then you should be careful about.
Interim order to continue.
For 2 days only.
Yes, ma'am. Interim order to continue.
Yes.
Okay.
Lease the matter after for second week of September. Both the matters.
Interim order to
Yes.
My lord, interim order.
Yes. Yes.
28.
My lords.
Yes.
May it please, Your Lordship.
Yes, ma'am.
On the last occasion, it was ordered to send notice through Dasti, but I had checked the records. The lady herself received the notice earlier.
Received.
Received. It is
why don't you-
record, my lord.
Where is that?
Devasmita Nava is approved in number 2.
So it says.
Receiving of reason.
It's not okay.
28.
Pressure is not really.
Appeal procedure. Order the
Looking at that, whether not could not be issued due to till today. Could not be issued to operate due to just the process.
No, the press admission.
I'm ready to pay the Dasti amount.
The counsel for the petitioner did not receive the notice. You have not collected the Dasti notice.
Yes.
I will receive it today itself. But you may kindly.
File the process. Dusty notice is ready.
Yes, I will take it.
Stay is operating.
Your Lordship. Pardon?
Is there any stay?
No stays there. No stay.
The Dosti notice directed to be issued by order dated 18/3/2026 would not be approved as the land council of the Commissioner did not collected the notice from the registry. Mr. Representative appearing for the petitioner submits that during the course of the day, you can go
Yes, Your
and
Lordship.
the course of the day and you collect the notice and take steps for serving this. And
If I may be pardoned,
please, madam.
if Your Lordship may be pleased enough to grant an interim stay in the meantime.
No. Notice has been issued last time. 2 hearing, 3 hearings taking place. No stay. Yes.
No issues. I'm highly obliged.
Yes. 29.
I may be pardoned, one item 94 is there. I'm not well at all.
Okay. I'll
So
take
if
next.
my associate.
No, I'll take it next week. Give a date.
No, my lord, it is actually amicably settled and both parties are available on VC.
It's all right. You need not be there. I'll do it.
I'm deeply obliged.
Is there any difficulty? You must tell me. You're
Will you?
Yes. Yes. 29.
Notice order served, but OP 5 is already appeared.
Sorry?
Pursuant to my lord's notice, I am appearing for appeal packet number 3 and
It's
5.
already appearing.
3 and 5.
3 and 5.
Notice is 5.
3 and 5. What about 2, 4?
Notice has not been made sufficient, my lord. They are not residing at their proper address.
Take first step.
Yes.
First step. So also appear for 2 and 3 and 5. 3 and 5 entered appearance and file. Wakalat now filed.
Yes.
Wakalat now filed. However, service on respondent number 2, 4 and
1.
2 and no 1.
1
Two
step.
and
2 and 4.
2 and
2 and 4. Not
two
it,
and
completed. So therefore, take steps.
Also notice utilized.
Yes. And so notice being utilized for the purpose of service. Yes.
My lord, fixing the date.
Oh, we are fixing second week of September. Yes.
Hon'Ble.
30.
Last occasion also he was not present. My lord, may kindly speak.
Indicate the notice has been delivered
Yeah.
to the opposite party number 80 who returned opposite party after service. None appeared for 2 and 3. The reading of this note and which indicates that the notice to opposite party for return undelivered on the postal and there is no person. 4 has not been served.
My lord, who is OP number 4? Kindly see
You
the
are appearing
person.
for?
I am for the petitioner.
You are appearing for?
I am for the complainant, the DB wife.
Respondent what?
I am respond number 3.
Savitri.
Yes.
1.
1, my lord. Who has filed the DB proceeding? And the wife.
No, but let us see for the service part.
My lord, may we see the constant.
You are appearing for 1.
1.
And who is appearing for 2 and 3? Nobody is entering appearance.
Nobody else than the mother and father of
Okay,
the
service is complete. Who is 4?
Who is the father?
No, Sasmita Rautrai. 4.
Where is the married sister?
Married sister.
Okay, you can. That's a yes.
The petitioner.
Yes.
And the DB proceeding has been filed by me. Your lordship may kindly see the order.
The DB proceeding.
Yes.
The proceeding under Annexure 1, my lord. Prior to the
You filed the DB proceeding against your husband and in-law.
In-laws.
In-laws. Okay. Yes.
And the order your lordship will see Annexure 5 is interim order.
No. First, you are for petitioner?
I am for the petitioner.
Yes, tell me.
Prior to the service of notice, summoned to the present petitioner, the order has been filed. Notice has been served under Annexure 3, Lordship C.
Annexure?
3,
Three,
page
yes.
19.
This was for 1st June 2024.
1st June 2024. Then the present petition.
Date was fixed on 22nd June. July. 22nd July.
Petitioners appeared on 22/07/2024.
When the order was passed?
Order was passed.
Where is the order?
Order was passed 28/7/2023.
Where is that order?
Order says 27. There's 26 perspective. Annexure 5.
27.
Annexure 5.
28. 28/7. Yes.
Date of argument 27/6/2023,
Let us see.
28/7/2023.
Let us see first. When
Was issued on 1st June 2024.
1 minute. Let us see. Say 22nd. Advocate you on 22nd 22/7/2024. Come to
Madam,
page
madam.
22.
Sir,
Your lawyer have entered appearance.
Madam.
Yes. 22nd July.
Madam.
Yes.
Prior to the appearance, the order.
No, when the order was passed, impugned order.
Impugned order passed on 28/7/2023.
So then 22nd you have already entered appearance. How prior?
No, my lord. Present petition was appeared on 22/7/2024.
Come to page 22, proceeding dated 22/7/2024.
24. Order has been passed as 23.
Where is that impugned order? You said 23.
Impugned order under Annex 5. 28/7/2023.
23. Okay. Yes.
Prior to the appearance.
Yes. What do you say?
My lord, may kindly turn to page 21.
21. Yes.
This order is dated 28/3/2023.
Advocation
Not files Hajra. SR against one year back after sufficient service as per postal tracking report. SR for OP number 4 after insufficient service. Hence issue fresh summons to OP number 4. Since OPs 1, 2 and 3 are absent on repeated calls, no step taken. They have been set.
You have been set ex parte.
Sir, they have to servicing of notice panel.
No, kindly see. Page 21, what he read. Proceeding dated 28/3/2023. Just read. You have been set ex parte, thereafter the impugned order was passed. Thereafter you entered appearance.
Summon has been service panel, the original summon.
Then you should have asked, you should have challenged that order dated 28/3/2023, setting you as ex parte.
No, they have to service on notice.
Just read the 20.
My lord.
Read that. Read that order. Read loudly.
Order has been reflected. But
read loudly. Just see. Sufficient service. As per the postal tracking report. Even then none appeared, therefore proceeded ex parte. Why are you that if that is the ground, then you don't have to.
Actually, notice has been served upon the present petitioner. One.
What can I do? Shall I go with the proceeding or shall I by your oral permission? Proceeding says that to August 20th, March 23 you have been served.
Notice has been served.
Again, don't repeat it. You tell me, you satisfy me whether you challenge this order.
Next week I will.
Next week you will manufacture something or what?
No, order to entire order sheet.
Just see the order.
But he has annexed the entire order sheet. It is his document.
You yourself have filed the certificate copy.
They have to service of notice. The present petition is set to expire.
I don't understand. How will I make you understand? If the proceeding says that the service is complete, you have been set ex parte. The first thing is you should have challenged that order. Saying that I have been proceeded ex parte wrongly, service is not complete. Because after 1 year you are entering appearance. If you enter appearance after 1 year, you should have moved an application saying that I have been proceeded ex parte.
Someone has been sufficient from the petitioners under Annex 3, my lord. 1st June 2024.
What will I do with this proceeding? 23 proceeding?
I will verify the entire order sheet.
My lord, now 3 lakhs is dues. 3 lakhs is dues. And it's an appealable order.
It is your petition. You have filed the certified copy of the proceeding. The proceeding says that you have been set ex parte in March 2023.
Notice has been served.
Except that you have anything to say?
Next week I will.
Next week, what will you do next week?
I will verify the order sheet to what when the notice has been served.
Okay, next week.
My lord, what has happened?
He is seeking, he wants to improve.
My lord, kindly see section 29. My lord, kindly see section 29. It's an appealable order. How 482 is maintainable?
We'll see next week.
And 3 lakhs is
Monday.
Due. Let him speak me. How will I run, my lord?
Monday, let us see. He is not prepared, I know. He is not prepared. Except one sentence, he is not speaking second one. That's the problem. You read it properly, come. You have two difficulty. One difficulty, you have been set ex parte in 2023, you have not challenged that. Thereafter, an order is passed. That order is appealable. Without filing an appeal, you have filed 482 petition straight away. And the ex parte order has also not challenged by you. So how will you get over all these things? If you can get over by Monday, you get over. If you can change the legislation,
Your Lordship,
law and-
so see, fresh requisites he does not file.
all right, let him explain. He has difficulty. He explained it. Monday, no adjournment. Partly argued. We said Monday, no further adjournment. Yes.
31. With the permission, I plead to issue, my lordship.
Yes.
My lordship, this IA has been filed for extension of time to appear before the learned Nyadhikari.
Extension of time.
Yes, my lordship.
You're supposed to surrender on 30th.
30th.
And extend up till 25th, 25th August.
Obliged.
No further extension. Yes.
Okay, my lordship. 32.
May I please, your lordship? Lord, appellant in custody since 4/4/15, more than 4/4/15.
Yes.
And appellant already undergone more than 11 years in custody.
11 years.
11 years, 4 months.
11 years.
And appellant once allow for interim bail 6/5/26, order dated 6/5/26 for 1 month.
Sentence is 20 years.
20 years. 376D 506 and 6 books act is there. And already surrender certificate is there.
Your earlier bail application rejected.
One granted interim.
How many of you are there?
Who appellants?
Get the report. Huh?
Surrender certificate is at
Let,
flag
let,
G.
let us obtain the report. Okay.
Certificate and
Yes.
Is it-
custody certificate.
Custody certificate, antecedent and jail conduct.
Yes.
Okay.
And conduct during interim.
All this. Yes.
And date.
I'll give you the second week of September. Yes.
34.
Obliged, my lord. 34, madam. In this case, earlier 3/4/2025, the government advocate was directed to produce the custody certificate of the petition, also
Yes,
the report
we
of
have
the.
that.
Not received next week. 2 times already filed, only 10 more.
25. April 25 this order was passed.
25 ତା earlier order ମଧ୍ୟ ଯାଇଥିଲା direction ହେଇଥିଲା. More than 10 years in custody.
Earlier कब ହେଇଥିଲା?
Next week. I will obtain this.
Order dated 14/11/24, 7/12/2024 and 3/4/2025 has not yet been complied by the state, and also appearing for the state seeks last opportunity to comply with the legal matter. 28th.
Yes, ma'am.
Yes.
35.
Before your lordship is in custody since more than 9 years, 3 months, 8 days.
9 years?
9 years, 3 months, 8 days. He is before your lordship for interim bail. Conviction is for 20 years. At the time of offense, he was a juvenile.
Your bail application was rejected.
Once rejected. My bail.
13/3. 13/3/23.
23/3/2026. and
Thereafter,
number 1286.
thereafter it has not yet been.
Which
I'll call for the
to view the prayer after the completion of 50% of the punishment period. That is there, your lordship. I am not on merit, your lordship. Interim bail only on the ground of mother's coronary angiography is to be.
Where is that application?
Yes,
IA number?
your lordship, 565 of, sorry, 1286 of
1286.
lordship.
Interim bail. Your mother is not well, huh?
Lordship.
Okay. This is an 1286. It's an application. 1286. It's an application for you are the sole appellant in this.
Yes,
You can't deny.
Because at the time of connected matter are below there, but at the time of occurrence, I was a juvenile. That is why I was being tried before children's court.
This is an application 1286, application filed by the convict Srikanth Naik for interim bail on the ground that his mother is terminally ill. He has also enclosed certain medical documents to substantiate this case. Issue notice to the state to the instruction after verification of the health condition, verification of the document to fit the application, release the matter on 25th. Verify and tell me. Yes.
Obliged.
Yes.
And CORAM two appellants are there. So one Kedar Naik was also in jail criminal appeal 8 years.
We'll see next time. Yes. Yes.
56.
The appellants were sentenced to undergo arrival for 10 years, madam. And they are in custody since 6 years, 4 months, 11 days, madam. And 2 months were in interim bail, madam. And they are surrendering and under annexed 2 minor surrender certificate.
You have already surrendered?
Surrender minor 7/11/2025.
7/11/25. The interim bail was granted to you on 18/7/25.
Yes, madam. Thereafter 8/9/2025 released on interim bail.
Okay. By the order dated 18/7/2025, the appellant. All the appellants or which appellant?
Two appellants.
Appellant number?
1 and 2, madam.
1 and 2. Appellant number 1 and 2. Granted interim bail for 2 months. And when you surrender?
Madam, 7/11/2025.
7/11/2025. It is the appellants who already surrendered and filed the surrender certificate. And now this is an application for grant of regular bail. This content was also for the petitioner for appellant that the appellants have already undergone more than 50% of the sentence imposed against them. Then the state obtain the custody certificate, criminal antecedents, and the jail permit for the second, third report. Second report. And get a certificate. Yes.
37th.
Pass over.
38.
Obtained conviction, your lordship, under section 6 of the POCSO Act, your lordship. And I have
When your application was rejected earlier?
I don't think it was rejected, your lordship. The interim bail was granted to attend the
objection
obscure ceremony of his mother. And then I surrendered in time, your lordship. And PW reached the victim, your lordship. That's a kindly see your statement.
No, have you filed objection? Yes, ma'am. Huh? Where is the objection? Because the last direction was on 24/2/2025. There was a direction.
Nothing is there, written objection not filed.
Not filed, my lord. Not filed.
Pursuant to the order dated 24/2/2025, the State Council has not filed the written objection as has been directed in the light of the judgment for the Honorable Supreme Court reported in 2014 9 SCC 177 Atul Tripathi versus State of Uttar Pradesh and others. The State Council seeks final opportunity to file such objection and they can do so within 2 weeks hence. Please the matter. Chapter, please.
39.
Please, Lordship. The present appellant may not convicted for offense under section 417, 493, 372(1).
Sentence?
IPC 14 years, Lordship.
14 years.
Lordship.
Okay. Undergone period?
And inside now custody my lord, from the date of judgment, and so also during trial he was on bail. And during trial, my lord,
Let us get to the custody.
now total my lord, 5 years, 7 months, 16 days.
20 seconds. Yes. Get all the 3 certificates. Yes.
40.
Yes.
RI for 20 years.
Yes.
I am for the informant.
Informant.
Conviction.
Who is there? Paraplet? Nobody is
Sorry, not there.
Is in custody. None appears for the appellant. In the interest of this is again. Also, Mr. Sahu appears for the informant. Please the matter till third week. Yes. September 3rd week.
41.
Conviction for 20 years. Active in custody since 14/6/2021, Miller. Last time also called for the
20 years, huh? 20 years.
called for this.
For the offense?
Offense is Poksha.
Pokso is there, notice also
Notice. Notice was issued.
Yes, my lord, notice was issued.
What about service?
Which was called for also last time. With the
What about service?
My lord, the last occasion, my lord should direct the serve the provide the copy of the deposition. No deposition copy is received. Deposition copy served.
Have you served or not?
No, deposition copy there रहेगा, there purchase order.
Forget about deposition, service of notice of.
That is sufficient.
Sufficient.
My lord. And the report is also with us.
Give me. When the notice was issued?
My lord, 2012-2023. 2012-2023.
2012.
Order dated
2012-2000. Okay. Pursuant to the order dated 20/12/2023, notice on the informant public, the victim has already been served. Served on रमेश पात्र he has signed on 12/2/2020.
2024.
20 it is written, just see.
That sign it.
Just see.
Yes, I that 20, but his signature is 24. By
24. How do I know? His signature is 20. Whether you obtain the signature from somewhere else, I don't know.
So you can take the fresh notice too.
Pursuant to the order dated 20/12/2023, although the State Council submits that notice has been served to the informant. However, this notice appears to be not sufficient, hence this notice to be taken up to serve the informant. Through the IIT with proper format. Lease the matter on 28th.
Fresh notice, my lord.
Fresh notice.
42.
Appellant is a lady, my lord. Convicted under section 304 part 1. Sentenced to undergo RI for 10 years. Out
How
of
much
10
you
years,
on?
my lord, around 3 years, 3 year, 2 months.
3 years?
2 months, my lord.
Okay.
Here, my lord, the case of the prosecution is that deceased was a antisocial. On the date of Ali's occurrence, he came near to the clubhouse, gave kick blows. Thereafter, the co-accused Nakulo, he came to the spot, restrained him. Deceased assaulted to the Nakulo. Thereafter, PW9, who is the eyewitness, he came to the spot, restrained them. Thereafter, deceased again went to the house of appellant. He pelted stone, thereby damaging to the car of the appellant. Thereafter, co-accused persons Nakulo, Kantaram, they came, tied him, then assaulted. Subsequently, he was shifted to hospital.
What is the role ascribed to this lady?
My lord?
What is the role ascribed to this lady?
My lord, so far as the PW9, my lord, he is eyewitness. He has not stated anything against this witness, my lord. He was, as because that was the premises belongs to the appellant.
What is the role ascribed?
My lord, he was just standing there as per the witness of PW9.
You are appealing
I
for?
am appealing for the interpretation. There are eyewitnesses. W9,
22 also eyewitness. 22 also eyewitness.
has categorically stated that that the petitioner, she herself brought over iron used for club and directed other accused persons to assault the present.
Okay. Get the custody certificate and all.
My lord,
let this custody certificate and jail conduct and antecedent clearance.
It's short dead, my issue.
I'll keep it. I'll give it. 28. 28. 43.
My lord, there was already out of 10 years is 6 years, 2 months in jail custody lordships.
6 years, 2 months.
Yes. Lordships are there.
Let us get that custody certificate and jail conduct also. Huh? Jail conduct, custody certificate and antecedent is already undergone for the long
So
time.
that lordships.
I'll put it on 1st of September. September, yes. 44. Yes, yes, madam.
The appellant is charged with section 41, 294, 322, 326, 307, 50 IPC. However, he has been convicted under section 341, 323.
The sentence you tell me.
Sentence is 7 years.
325, 7 years. Okay. Undergone period?
Undergone period is approximately 6 years.
Sorry?
6 years. This can be arrested on 5/5/2021.
You already undergone 7 years. 6 years.
6 years.
Show me.
5/5/21 was the arrest. 5/5/21.
Show me anything to show that you have undergone about 6 years. Any document you have? Out of 7 years, you have already undergone 6 years. That's what you are saying. You are entitled to bail. Show me anything from where I can, confirm that you have already undergone that period.
The judgment shows that his date of arrest 5/5/21.
In between, whether you have
No.
gone in interim bail or
No.
parole or anything of that sort.
No.
Get a report. Report. Please the matter on 17th. You get it urgently.
Custodian.
She says out of 7 years, she has already undergone 6 years.
No, my lord. I have talked with the appellant and the
Item 43.
Item
44.
44. 17th, huh? 17th. Yes. 45. Sorry?
Regional petition is there.
Sorry?
Regional
Prisoner's
petition.
petition. Which one? Dated?
Black Sea.
Black Sea. There are two petitions. But you know, 20, when was it? 24. 20.
Victim is a deaf and dumb girl. And that is the pregnancy and the
Chitranjan Sahu. You want to get Chitranjan Sahu. You filed Vokalatnama?
Yes, sir, we filed that.
Already filed, huh? Pursuant to the prisoner's petition. You take. What is the date of this prisoner's petition? 5/3/2026. Mr. Chitranjan Sahu has already filed Vokalatnama on behalf of the appellant. Yes.
The solution that I am allowed to take the deposition copy to.
Mr. Sahu led counsel for the appellant admits that he doesn't have the copy of the brief. He may be allowed to obtain the same. Mr. Sahu can obtain the same soft copy to the receipt, soft copy CP. Yes.
46.
Maybe 6 books of 6 books on along with other ones. Last time I got a notice was served on dated 7/7/2025.
Service.
Yes, service notice. And custody near about 6 years out of 20 years, but of 6 books.
You served in that format?
Yes, no.
The informant as well as the victim, the notices of.
Where is their signature? Nothing there.
In the back. I will give in the original.
They served. What is the date? Service?
25, my lord, in the year of 25.
Just 25. Right.
That you can provide the original.
7/7/25. The informant of the victim has already been served on 31/8/2025.
This is the original.
Whose report is? Whose report?
This is the original copy. The back side is from. The two, one informant and other the victim.
I see bottom of PS. That find the proof of service. Proof of service will be taken into account. That's why service non-appears for the victim. Victim. Mr. Das, you assist for victim. He will appear. He will appear. Mr. Das, we presented before. He requested to appear for the victim to assess the court, release the matter, and soft copy of this PCRC.
Can I say before some copy?
Copy, soft copy, I have to. Yes. Release the matter on 28. 28. 28.
Okay.
Yes.
6 years custody certificate.
6 years out of
20.
Right. It's all right.
Always.
Yes.
47.
Pardon to make mention, my lord. Though the prisoner's petition is from District Jail Balangir, in the item of 44, though the prisoner's petition is District Jail Balangir, now he is in sub-jail Kantamanji.
Tell him that he will get the report from there. Huh? Make him understand where to get it. Yes.
47 is
TP2C. Eviction is for 10 years. I'm in custody for 4.5 years. 112 kgs of ganja was seized from me.
10 years sentence, huh?
Yes. 10 years.
4.5 you undergone. I'll get your conduct certificate and indicate. Huh?
Yes.
And conduct certificate, and I list it on 3rd of September.
Yes.
3rd September. Okay. Yes.
Hey, appearance before appeal. Let it be taken.
48. And there are two matters. There are two matters. It seems.
I'm for second. I'm for second one.
And why is two appeals?
Sabine is the driver. One is Sabine is also the
Same name.
same.
Same name.
Name is same. Okay, that's the confusion. Okay.
Trying to be passed over. 14.
Pass over. Yes.
49.
May I please your lordship? I have filed IA number 176 of 26 for interim bail. The wife of the petitioner is suffering from heavy chest pain and also she consulted doctor.
I number? You said I number?
176 of 2026.
This is the case of POCSO. Notice has not been issued.
Petitioner wife also referred to the cardiology department of Capital Hospital. Yes, sir.
Mother, your mother is not.
The wife of petitioner.
Okay. This is an 176. An IA for interim bail moved by the convict appellant on the ground that the wife of the petitioner, his wife, is terminally killed. He has also filed supporting medical document. Let the state council verify the same by state appealing. This is one of the offenses POCSO. We issue notice to the informant of the victim by next state appealing. Verified. Take out the notice also. Take out, yes, take out the notice also. Release the matter on 7th of September. Yes. 7th September. Yes.
Item 50.
My lord.
Yes, sir.
Punishment is 10 years. Notice already issued, man.
Sorry.
Punishment is 10 years, man.
Yes.
10 years. T77, radio section 4, POCSO.
Certificate. How much you have undergone?
My lord, around closer to 3 years, my lord.
Let us get the certificate. Yes. Yes, I'll just resume after this 5 minutes.
Yes. This is an 82-year-old man. He has been convicted under 376(1). Out of the 7 years of punishment, he has already inside the custody 6 years, 2 months, 25 days.
So
I have to take the instruction from the jail operating.
6 years he has already undergone. 8 years.
7 years, so because
8 years. 80-year-old.
yes,
82.
Now 82. Obviously.
Now
24 he was 80.
80.
Now 82.
Monday.
Today's no. Day after tomorrow.
Yes.
82 years.
That's it.
Day after tomorrow. Yes.
But
Otherwise, I'll release him on the ground.
victim is mentally disabled, and the medical evidence proved, my lordship.
That apart, I'm not on merits.
Yes, my lordship.
I'm not on merits. Day after tomorrow, you tell me. Now, where from I'll get that you are already there in the custody for 6 years?
From the judgment,
Let us see.
when the page 2 of the judgment,
Let us see. Yes.
page 2
Page
of the
2.
judgment in the last column,
Mhm.
from 14/9/2015 to 14/11/2019, he was in custody.
Yes.
And after that, 10/7/24, that is the date of judgment. The sentence is on 12. He is inside the custody. Right now, he is inside the custody. He has not released.
Okay. Your earlier bail application was rejected?
No, madam. That is pending. Along with the appeal, the bail application was filed. That was pending.
Nice.
Let us see the charge sheet. Let's see the charge sheet. What is this charge sheet? What is your name? Your name is Bondhua. Bondhua.
Informant is the mother who taught the posted.
No, from the final form, you show me your age. Final form. How will I confirm the age?
So the charge sheet is the column number 13.
Yes.
The age is written as 70. The charge sheet was given in 2015. 31.
Column number you say?
Number 13.
13.
Okay.
Let us see 13.
Column number 13, my lord, page 3 of the charge sheet.
Yes.
Particulars of the accused person charge sheet.
Hmm.
My lord, in the Roman 3, date oblique year of birth, 70 years.
Yes, I'll pass the order. I'll pass the order. Yes. Yes. Next. 52. Yes.
Here the petitioner is languishing in jail custody since my lord 24/6/2022, whereas the entire discussion of the Lord and trial court that is against the prosecution, and also victim also never make any such allegation against the present petitioner. May I draw my lordship's attention first page internal page 50, whereas the victim stated that she was staying in the house of PW1.
Your bail application was rejected on 29/4/2025.
Sir.
Yes.
Sir.
On merits.
Sir. Sir. The victim stated
What
that
is
she was
the
staying
period undergone by now?
Sir.
What is the period undergone by now?
22, that is 24/6/2022.
Custody certificate, antecedent, and jail conduct. And list the matter in second week of Shukran. I'll obtain it.
Prosecution, sir, they are.
Okay, but on merit.
You are not relying on prosecution.
It's all right. I'll get the certificate, custody certificate, and all. Let us see. Yes. 53.
The accused in jail custody since 15/6/22. The conviction 20 years, my lord. And at the time of occurrence, the age of the accused was
Service, madam.
Yes, my lord.
Service is there.
Today only there, sir.
Yes.
the government language is victim rogla. ବର୍ତ୍ତମାନ ତାର କୌଣସି ବର୍ଷ ନାହିଁ।
Yes, pursuant to the order dated 5/8/2025, notice on the opposite notice on the victim of the informant has already been served to the IIC Sadar Thana Hon'Ble. A report to that effect has been placed on record. Despite the service, none appears for the installment of the victim and so on so is appointed in the to assess the court. Leave it to me as a point. In the meantime, let the state council obtain the custody certificate based on the case of the incident of the convict. I am appointing someone. Yes. Please tell it second week of September. Yes.
54.
54.
May.
Leave it me.
In the meantime, two of the applicants have been granted bail. This is a case under section 304B, 498A, and 4 the DPI, the present appellant and along with
Yes.
May I please?
Yes.
The present appellant, along with other two appellant, co-appellant, they have been convicted in the instant case, in a case of 498A, 304B, and 4 of the DPI. Two appellants, they have been granted bail. Appellant number 2 and 3.
Yes.
If a lordship will possibly see, initially charge was framed under section 4.
7 years. How much you have undergone?
No, ma'am. 2 years, 3 months.
Who has been granted bail according to you?
2 and 3. Father-in-law, mother-in-law. There is no specific allegation from the owner from the judgment by the itself. In the judgment, it has been mentioned that they were living happily. The present appellant was serving at Qatar. The occurrence had taken place at Bhubaneswar. At the relevant time, the deceased committed suicide. There is, my lord, for that reason, my lord, for better appreciation, 306 has been deleted. There is no question of abatement to commit suicide for the dowry demand. 113A goes, my lord. He has been convicted along with other persons, other appellants, those who have been granted bail in a case of 304B. Taking the presumption of 113B, soon before her death, what is the question that where is the judgment that soon before her death, the present appellant along with others, they have abated or demanded dowry to commit suicide by the deceased person. There is nothing. Rather, it has been 45 from the judgment, my lord. I am placing few sentences. Only 1 to 2 minutes it will take, my lord. From the judgment itself, it is prima facie found they were living as a happy, maintaining their happy conjugal life. That is the evidence of PW1. PW1 is non-else the mother of the deceased, my lord. Your lordship may can see, I have marked to that extent, my lord.
Come to PW1.
My lord, I am placing. PW1. In point is my husband. I know the accused person present in the dock. About 9 months back, the incident took place. About 2 years back, my daughter met there. There is a demand of dowry by the omnibus allegation. At the time of marriage, the father and mother of the accused, Ramo, demanded cash of rupees 1 lakh. We paid 60,000. We also gave so and so, so and so. After 2 months of the marriage, all the accused persons, they have assaulted Sanjukta, demanding rest 40,000. This is much allegation against all the persons. Sanjukta was so and so, so and so. The mother-in-law, Sanjukta, informed that Sanjukta is dead. We came to the in-laws' house and Sanjukta and found her lying there. I was examined by the police. My lord, to that extent, my lord.
And who is the doctor?
My lord?
PM doctor?
Doctor, my lord. PW 18. Death is due to suicidal hanging. For that reason, this is the judgment, my lord. It can be borne out from the judgment that there is no assault, nothing else. Only
yes, madam.
Yes, my lordship. Can I have a glance to the PW doctor?
No, doctor, it's all right, but PW1, but she says that the demand is made by the father-in-law and mother-in-law. They've been granted bail. He doesn't say, the PW1 doesn't say that this husband for the deceased has demanded the money. Just see the father and mother for the this petitioner has demanded the dowry.
My lordship,
That's the examination chief and further also.
my lordship, when she died, my lordship, she was pregnant. That was also confirmed, and the husband is first responsible for her mental conditions, and that what has proved.
What is the material? Just show me.
Yes, ma'am.
The PW1 doesn't say anything.
Yes, ma'am.
About the involvement of this petitioner. Who are they? PW 6. Yes.
PW 6, na?
Yes.
Yes.
I don't know the Suresh Kaptoy, the informant. I know Ramopani and Indramani Pani. but I do not know Sushilapa. I do not know the date of incident. Police has been examining.
What are you going to do out of this?
There is the allegation because the husband is the.
And he is a hostile witness, doesn't support you. What are you?
There is some part, my lordship, there is a dowry.
Which part?
Dowry.
Merely he knows the Rama Pani. Doesn't mean that he is involved. He only, see, this witness only says that I know Rama Pani. That's all. Have you read the file or not?
Yes, my lordship, but I.
Show me which part.
My lordship, can you pass over? I have to.
That is better.
Yes.
Let her read it. She is not ready.
Page 14 of the judgment.
Let her read it. She is not ready, it seems. Yes. Pass over.
He had good relationship with the accused person.
Because we see two accused has already been granted bail, the mother-in-law and father-in-law. There is specific allegation against them.
Yes, ma'am.
Then if that is the case, then why the husband, merely because his husband, that doesn't mean that he is not entitled to bail.
My lordship,
Yes.
I will set.
Yes. Next. 55.
Conviction is 26A of IPC.
Three?
26A.
Yes.
VW
Sentence?
10 years.
10 years. How much you want to go on?
1.5 years.
2.5 years. Yes.
PW4 is the victim.
PW4.
4 is the victim and PW7 is the doctor. There are two appellants.
Let us see PW4.
For your lordship, 6 PW4, they were on bail during trial.
That's right. No.
So kindly see the observation granting bail to them.
No, that before trial, some observation is made. Let us see the evidence.
Evidence, your lordship, there is evidence.
Then,
there is no
during trial, something happened. You got bail.
What happened, your lordship? There is no permanent disfigurement, and she was married. And the board asked him to produce the recent photographs. He denied to give the recent photographs.
I have to see the, after conviction, I have to see the evidence.
Yes, yes.
Evidence is there, then I can't help you. If evidence is not there, then some doubt you can create.
There is no, there is a allegation is that the thrown estate in the
Acid
Yes,
data.
so the victim said sleeping. And the doctor said that
This second week of. Let us see, get this contact also. Yes.
PW1, PW2, and.
Yes, next, 50.
56.
May I please your lordship? Internal is about 80 years. Yes.
Yes. I asked you to. Yes.
Need some more time, my lordship. Regarding that judgment, I have to.
Will you get it after he dies?
No, my lordship.
He's 80 years now.
Yes, my lordship.
Then day after tomorrow.
But
Day after tomorrow. See, the other matter is also 80.
Yes.
No, the other matter I'm going to pass the order, but day after tomorrow. And get it. Day after tomorrow, yes.
57.
Day after tomorrow, 57, yes.
Lordship, out of 20 years sentence has already undergone 11 years. Has been dismissed. More than half of this sentence is already undergone.
Offense?
3760 lordship.
Notice was issued to the victim.
Actually, the head of tail is the informant.
Notice was issued to him. Informant.
not issue.
Informant of the victim. In the meantime, through IST. In the meantime, the custody certificate, jail conduct and antecedent of the particular from the appellate be called for from the concerned authorities. These the matter and schedule. Call for the yes. Next.
8.
Yes. Sorry?
6 for POXO at the industry. They were in relationship and the Bahrain and the FIR lost by the custody since.
Yes, service matter, service.
Last occasion was directed.
Yes, I know.
No, my lordship.
You have not complied. See, the order was of July 25. Last time on 13th January, you took time to comply.
One more chance. See, mo pakhku asithila compromise time baha korbe puo radyo chi baha.
But the record has to be complete. Service was directed to be effected to the. Huh?
Last chance.
Right, the right order. By the order dated 7/7/2025, the victim oblique the complainant was directed to serve to the IO of the case. However, the service could not be effected. When the matter was taken up on 13/1/2026, the state council sought after opportunity. However, again, the service report is not placed on record. By way of last and final opportunity, 1 week time is granted to the state council to obtain instructions regarding the service of notice from the informant of complainant, release the matter on 19th. 19th. It's made clear that no further opportunity can be made.
59. But on the basis of the prisoner complaint, I am appearing with this. There is a delay.
Have you filed the Wakalatnama? Yes.
There is a delay in filing the appeal. And already.
Delay how much?
Delay is the matter 218 days in my calculation. Notice issued to the.
250 days. 250 days. Yes.
Notice issued since 29/7/2024.
Notice heard. What are the offences?
Offense matter 3763 20th.
Okay, I'll condone the.
Folksy.
What is the status of service of short?
Not through IAC, my lordship. It was not directed to through IAC.
Okay. Delay condone. Executed. The judgment of conviction and order of sentencing so admit, delay condone and admit, and on 29/7/2025, IA 363, right? Notice was issued to the respondent number 2, victim oblique informant. However, there is no report of service of regarding the service of note. Let the fresh notice be served through the IAC. IAC read the matter. Second week of September. Yes.
60.
Yes, the appellant was sentenced to undergo array of undergo minor for a period of 6 years under section 10 of the book. Out of out of sentence period, when the attendant undergo.
Notice has to go.
1 year, 8 months.
What is the interim order?
Realization of state realization of
It has already been admitted or not?
admitted and
All parties. Okay. Notice was not issued.
Notice already they appeared and filed their manner.
You are appearing. Who is appearing there?
I'm appealing for informant.
Then you tell me.
Can you see the para one?
Para one of? Are you opposing? Are you opposing the bail? Are you opposing the bail? Yes.
Can you see para one of the objection, my lord? This is such a heinous crime that I cannot read. Para one. Can you see para one?
Yes.
The actual matters of the case in that 8/12/2022, while victim was alone in her house in absence of her parent with her grandmother, the convict appellant called her, asked her to give water, but held her and handled her best. The victim managed to escape, but when the informant
That is the objection.
No, objection, that is objection, but in judgment, my lord, page 20.
Let us see what
Page
your
22.
conduct also.
The parents are, my lord, acquitted from the charges.
You are your cousin.
Now she is college going student, 17 years old.
My lord, the.
You application for interim bail. Application for interim bail. IN number 1. Yes. Got instruction.
Yes, yes. They just now received the instruction.
Yes. Yes. What is your instruction?
Again, good. Instruction is, Your Lordship, there is no criminal antecedent. Further on physical verification of the wife of Makuru Janga, namely Lakshmi Janga, is available in your house having sound health. এটা হচ্ছে তার ওয়াইফ রই এটা আর তার জেল পিরিয়ড অন্ডারগোনটা হচ্ছে জেল পিরিয়ড অন্ডারগোন হচ্ছে 6 years 9 months around 6 years 9 months out of 20 years.
No, no, but this is an interim bail on the ground of the wife's health condition. But the report speaks otherwise. What to do? Have you verified the certificates? Medical documents also. Medical documents.
Send the IA also to the IA.
Give me the report. Let us understand. Give me the report. Has he verified the medical documents which are enclosed? Has he verified?
I already sent the IA, but I don't know if he verified the medical documents or not. Say personally, the physical देखिला दे
Is he a conductor?
नहीं. सर ताले এটা
constable जाएगी देखी देबो हाँ बोलो छी certificate
Sir, Friday.
There are medical document you have to verify from the concerned doctor.
Friday na last one.
Has he done it?
I know. So Friday, let it come on Friday so that I'll get an instruction regarding the.
Right. You see he has filed some medical document.
Yes, Your Lordship. Yes.
It has to be verified whether these documents are authenticated document or
yes, Your
not.
Lordship. That.
And you have to ask the doctor who has given it. That is how the report comes. Yes.
Yes.
Yes. Right. Yeah.
Right. Friday after the night.
Yes.
Can period order gonta tike jutte oro.
Only on interim bail.
Yes, sir.
Period undergone 6 years. He himself says out of 20. Yes. 62. Yes. No problem.
The page 50. 5 years in custody, also for 5 years, my lord, I am in custody.
You are appealing for.
Your Lordship, I'm appearing for the informant. I'm having no instructions in this matter.
You said that I will file objection.
Your Lordship, on last occasion, after getting the notice, he just came and gave me the wakalatnama. I appeared, then he vanished, my lord. So I couldn't contact the informant even after that appearance.
But you are supposed to file objection anyway. What is the case? Let us understand.
Out of 5 years, 3 years, 12 days, I am in custody. Only for the 8 of the POCSO Act, my lord. Allegations that.
Let us see. The victim statement.
Page 40.
Who is the victim?
The informant and mother of the.
Who is the victim?
PW3.
3. Yes. Let us see.
Admitted
7 years.
6 years in that occurrence time, 6 years. And PW2 the mother of the this is the informant. PW10 It condemns to undergo 6 years concurrent arrest. I am in custody 3 years, 6 months, and to be precise, 4th day. Today. 6 years. Though the charge was 10,376 and so many other offences, from out of those charges, I am released or acquitted. Convicted 354A and section 10. 6 years.
Let us see the victim. Who is victim?
PW1.
PW?
1. Also
PW1.
15
years.
24.
15 years. Where is the on Saturday while my maternal called me to will not go to me.
Paragraph 16 onwards. Question posed by the court.
Paragraph 16.
16 onwards.
Question, yes. What is your name?
Name of
Your name is Chittaranjan.
Yes.
You are Chittaranjan.
Uncle.
He's the brother of the stepmother, madam.
Uncle.
You are appearing for the victim.
Informant.
Appointed by legal.
Class 7 student, huh?
Yes, ma'am.
He was staying with me.
What he has done?
Questions posed by the court.
Which question is relevant? On Monday morning, my father came to the village. So all this number
21 onwards.
What is the real offense? Let us understand. Ingredient. Huh?
Pardon.
What is the real act you have done?
My lord, in fact, he says to the answers, but answering the question to the court, I do not know what is the Parakamo. Thrice the court has put, and that is the basis, no corroboration, nothing. And rather, she could say in a one room, 3 child of my uncle.
Who is doctor? Who is doctor? She doesn't say that. She even doesn't know what is rape and what is the.
That's how the court says. Neither attributed nor could explain what has been done with her.
She's not able. She only says that.
Yes. That's why I've been acquitted from all the charges.
Let us see the doctor.
TW6.
6. Same day examination. Same day.
I
was at my post.
Medical examination. There was absence of any bodily injury, absence of any physical fluid, bone fracture. Yes. What do you say?
Met the consider well because after 6 and
There is nothing.
Yes, 3 years and a half. And my case will come there.
You are trying to argue your case when.
I objected heavily in another court, my lord.
He's thinking about the second brief while filing the first one.
Undergone period, you said.
Yes, 3 years, 6 months total.
Yes.
3 years, 6 months, 4 days. I'll pass you. Okay. Yes.
My objection, maybe.
Yes.
Objection.
Of course. Yes. 64. Yes.
Convicted under section 6 of for 10 years.
10 years. Undergone. antecedent.
Sir, ଏଠି ଖାଲି ଗୋଟେ instruction ଆସିଥିଲା ପୋଲିସରୁ ଯେ ତାଙ୍କୁ ସେ ଏରିଆରେ ପାଉନୁ ବୋଲି ତ ସେଇଟା
At least victim is already married to somebody else and she is staying. So far as the informant is concerned, my lord, she is dead.
No, service is complete so far as the victim is concerned.
That's like
Service, where is that? Service report. Notice was issued on 25/6.
ସେଟା ସେ ଦେଇଛନ୍ତି ବଟ ସେ ଲେଖୁଛି କୁଆଡେ ଯାଇଛନ୍ତି ତାର ହୁଏର ବର୍ଷ ନାହିଁ ବୋଲି ପାଉନାହାନ୍ତି ବୋଲି ହେଲେ ସାକ୍ଷୀ ଜାଣିବାକୁ ପାଇଲୁ ନୋଟିସ ଜାରି ଜମି ବାଡି ବିକ୍ରି ଅନ୍ୟ ଦ୍ରବ୍ୟ ପଳେଇଛନ୍ତି ତେଣୁ ନୋଟିସ ଜାରି ନ ହୋଇ ପରିବାରର ଅନ୍ୟ କୁଆଡେ ଜମି ବାଡି ବିକ୍ରି କରି ପଳେଇଛନ୍ତି ବୋଲି ସେ କହିଲା
Not married, they were staying together. She gave birth to a
ମତେ ଟିକେ ଆଡ୍ରେସ ଟା ତାଙ୍କୁ ଦେଇଦେଲେ ମୁଁ
Why did you give fresh address for that?
fresh address
Yes, address one I can see because after that date, child is.
The police can locate where they have gone. Police can locate. Right now, pursuant to the order dated 25.
Death of the child.
25.
The mother came and took her back.
Okay. Service for the notice on the informant of the victim has not been sufficient. Therefore, the state council should take fresh steps to ensure the service on the informant and victim. And in the meantime, the custody certificate, antecedent and jail conduct of the convict appellant shall also be obtained by the state court. This is the matter on 3rd of September. 3rd September. Yes. Service 3rd September. Yes.
65.
Item 63. Sub-condition will be provided.
You can take it. That is a standing order. Yes. 66, huh?
65.
65. Yes.
Please, Your Lordship.
Yes.
5-year conviction, my lord. He was in the bail, my lord, while the trial was there, my lord. And he has stayed almost 2 years, my lord. The convictions.
What are the offenses?
Offenses is, my lord, there is 363, 343, 356, my lord, 8 for.
Okay. Notice was issued.
notice is sufficient.
Notice sufficient.
Sufficient.
Yes.
Show me.
Right.
The informant had appeared
Yes.
in person
Yes. 2 years.
and opposed the bail. Oppose the bail. Service is complete, right? The pursuant to the order dated 25/6/2025, the victim appeared before the court in person on 6/8/2025 and opposed the prayer of bail for the appellant. However, today none appears for the informant. Only victim. Yes.
Yes, madam. Out of 5 years, madam, already 2 years he had already in custody, madam. So I'll appeal. I have filed an interim application also, madam. Then held down, madam. That is I-1588, madam.
Interim
I
bail.
have, madam, paid.
Interim bail for what? Serious health emergency.
Yes, madam.
Whose health emergency?
My wife, madam.
Have you filed any document to that?
Yes, madam. Even, madam.
The counsel for the appellant is pressing the application IA number 155 of 2026 for interim bail on the ground that the wife of the petitioner is terminally ill. He has, in support of his contentions, he has also filed certain medical document. Let the state council verify the same and place a report from the next date of hearing. Place the matter on 9th of September. Yes. Copy of IA. Yes. 9th September. Yes. Next.
66.
Yes.
This was convicted under section 354 only. In section 10 of this also act, there was a 5 year. The petitioner in fact was
Notice.
languishing in the perspective.
What about notice?
Lordship, they have appeared already.
Oh, so you are appealing. Yes. Yes.
Lordship, interim bail for 10 days given by this honorable court. But after getting satisfied competition, is not will be sent. Reason being, during that period, the obsequies has been over of the.
It's all right.
For that reason.
Yes,
The petitioner is languishing in the suicide custody for 1 year. 5 years has been under 5 years conviction.
Yes. Are you opposing?
Let's see.
Yes. Call for the custody certificate. He will conduct. I will select this second week. Let the certificate come. Yes.
And the realization of
It has already been said. No.
in
The IA, the first stage. No. Yes.
67. Item 67, I may be permitted to appear through virtual modes.
Yes.
Obliged. That's conviction for 20 years, dated 36/2025 under section 376(2) and 376(3) of the IPC, read with section
You are
6 of
appearing
the
for Mr. Mark. You are appearing for?
appellant.
Yes. Yes.
20 years conviction, my lords. 21.
Want to file objection?
I don't have any.
The informant has appeared, my lords, through her counsel.
Give the copy, he will file objection.
The informant has appeared, my lords.
He undergone 1 year of
Mr.
And
Mahapatra.
see the last order, my lords, the informant has already appeared through her counsel.
That he doesn't have the copy of the appeal paper book and not even doing the repositions. He will counsel for the appellant to serve the paper book, appeal paper book, along with the repositions. Reposition.
The custody certificate may also be called for.
You supply. See. Yes.
Obliged, my lords.
Next.
68.
The convicted under section 397 and below for part 1 is contains to undergo 10 years direction and relationship not conservative. I'll get a report then.
Not
Let us get
admitted
it.
yet. Not admitted yet.
Not admitted yet.
No. 60.
Not yet admitted, sir. Admit. There is delay, huh?
Delay already condoned here. 8/2025 order.
Although delay of 78 days for preferring the appeal has already been condoned by the order dated 8/8/2025, but the appeal has not yet been admitted. The appellants have challenged the order, the judgment of conviction order dated so and so, so and so, so and so. Yes. Capital zero, admit, call for PCR, so and so, so and so. I liख दो. Release the third week of September. In the meantime, the state council to obtain custody certificate, field conduct, and NTC conduct for the appellant. Yes. Third week. Yes.
69.
TCR I have called. Yes.
69, 5 years conviction. Must immediately pursued. And
What is madam, you are appealing?
I'm inside custody near about 2 years also.
Are you going to file objection?
You have to kindly see the evidence of PW.
No, she has to file objection if it. You want to file objection? Huh?
See, waiting for the chief.
So that's what I'm asking, madam. You want to file an objection? Okay. So appearance for the victim only complainant, informant, and seeks an adjournment to file objection to the bail period for the convict appellant. Release the matter on 7th of September. File in meantime, you file 7th September.
Only allegation, let's say, embarrassing in the road. That's the only allegation.
But she wants to.
I'm inside custody. I am using threatening. The imaginary allegations are there. I'm inside custody for 2 years, so let's see.
2 years.
5 years.
Out of 5 years.
That's kind of single allegation. Only allegation is embarrassing in the road. That's the only allegation. से तो 17 वर्ष में अभी बाहर चलो.
You are 34 years. Let us see the victims. What are the
PW 2 years.
PW?
2 years.
2. Yes.
Mr.
Twenty-six one. And sentenced to undergo RI for 7 years. The last notice was issued.
Yes, service.
No, the service.
Service. Pursuant to the order dated 10/10/2025, the respondent number 2, informant of the victim, has already been served with the report completed by so-and-so. Completed by IIC Kaliapat. Dated 19/10/2025. The report is taken into account. That's why service and PS for the informant. Therefore, so and so, the appointed is Lemake Iskari.
So out of 7 years, the apparent was arrested.
That's right, I am appointing Lemake Iskari to someone when nobody appears for the victim. And lease the matter on 11th of September. In the meantime, the custody certificate, jail conduct, and the antecedent of the petitioner be obtained by the State Council. Yes.
71.
For 5 years, I have already been working for 1 year, my lord. My lord, we have a glance. This whole evidence of the people that is one. My lord, it has also been dealt in the judgment. Notice, sir.
Notice or somebody has appeared perhaps.
Somebody has appeared. Who is it? My lord. May have a glance to running page 21.
The interim bill was granted, surrender.
Bill was also granted.
Surrender certificate.
Surrender after 15 days due to the death of my father. Yes. And my lord, may have a glance to page 8 of the judgment and running page 21. What is the evidence of the victim? At page 21, running page. During cross-examination, she stated that the place of tuition is at a distance of 500 meters to which he was going alone. The road is a crowded road. She never seen the accused before 24. The substantive sentence is 5 years.
Yes, 5 years.
Minor. The accused came from her back side and within 5 seconds he squeezed her breast and fled away. Who is the victim? Minor, PW1. Read PW1. Minor, the victim. And in this prosecution, I am testifying. The accused came from her back side and within 5 seconds he squeezed her breast and fled away with the motorcycle in a full speed. She had not fully seen the face of the accused. This is the my lord's allegation alone. On the basis of this evidence, my lord, I have been convicted for a maximum period of 5 years, my lord. I am in custody for 1 year already. This is the evidence, my lord. He has not seen, no TI period has also been conducted. She knew you. That is also there. I knew the accused. Accused there. I am no accused cannot see. She never seen the accused before. No. Kindly see the evidence. First paragraph. I am the victim of the case. Informant is my father. Yes. I know the accused. I don't know. Time. I am going to 24/5/2022, the date of occurrence. Only after she came to know the victim, accused. On 28th, I was returning from the tuition and I found that the accused was following me. A blue color motorcycle. Registration number from being sent to the house. I found the patient's father. And the police came to my house and recorded my statement. Statement was recorded, returned from so. Previous, before the incident also, you did the same thing. No. When the incident taken place? Minor, the incident took place on 24/5/2022. 24/5/2022. 24/5/22. But see the para 2 of the victim statement, victim evidence. Para 2. Victim had stated that on 28 again she came, but she ran away to her house. This is the allegation. But no such occurrence has taken. Repeatedly you have been doing it. That's what. No, my lord. What fact remains, my lord? What is the reason in this case? Why I have been convicted?
because the informant is known as one of the police officer of the of our Patagam police. That is why this case has been posted against me. That too after 4 days. My lord, the alleged occurrence took place on 24/5/2022. The FIR was lodged on 28/5.
Because second time you came, therefore.
No, my lord. Because the first earlier FIR was lodged.
Yes, what do you say?
The effective involvement of the present appellant by virtue of that attribution is clear. In your lordship, no consider.
What are the, there is no serious allegation.
No,
He came in a motorcycle and
this is the allegation. That too she has not seen. No TI period.
from the back he came and the 28/5/2022 is 22 is story. I think we should 1 year, huh? 1 year. 1 year undergone.
Further condition not to repeat that.
Sorry?
Condition not to repeat such.
Yes.
That will.
I'll pass it. That was the problem. Yes.
72.
Yes. 72.
72 item I has been taken away. But
I filed my wakalat yesterday.
Release the matter. Second week. Yes.
Name me kindly.
Yes, his name. What is your name? Give in don't show. Is it entered appearance for the appellant? You mean reflect in the cause list. Yes. 73.
73.
May please, madam. Convicted madam under 354 B, my lord. 4 years post-conviction, my lord.
So is there.
And my lord, the only good sentence.
Notice.
Notice ଯାଇଥିଲା 29/10/25.
Sufficient is not.
But nobody has appeared.
Huh?
Nobody has
I
appeared.
have to appoint the MLA school. Pursuant to the order dated 29/10/2025, notice to the respondent number 2, informant of the victim, has already been served, but he only the appearance on her behalf, and so is appointed in the school. Means the matter. A period undergone how much?
My lord, 17 months already undergone, and trial period was on bail. Only second and victim.
Okay, sir, and this last information for the appellant submits that the appellant is already undergone 17 months incarceration out of 4
Out of
years.
4
4 years. 4 years awarded sentence. Release the matter on 17th. Appointment of load for 1 month. Yes.
Appointment of
17.
legal aid council.
I'm a, yes.
My lord, has got a evidence copy of victim.
Keep it on 17th. You keep.
This is a sort. I can see. खाली गोटे वार्ड আছে খালি
Award council.
Yes.
74.
Result show. 10 of POSCO.
Condition under section 363 and 10 of the POSCO Act. Tenders to undergo arrest for 5 years for each crime. And within custody in the last 1/7/23, more than 3 years in custody.
More than 3 years.
Out of 5 years.
Out of a yes.
Notice was issued.
Notice.
So, but nobody has entered appearance.
Notice served, none appeared. Huh? Same. All these matters, bail has to be granted. More than half the sentence they've already undergone. The
There are
allegations
lots
are
of
minor.
consider
allegations,
that.
unnecessary. To appoint complete appoint this. 3 years you've undergone. Huh?
More than 3.
10th. Pursuant to the order dated 6/11/2025. Notice on the respondent number 2 oblique the victim oblique the informant has already been served, but none had entered appearance on Hon'Ble. And so on for his appointed within the victim and to court. Release the matter on 10th. I'll appoint someone in the magistrate security to complete the record thereafter. Yes. Grant these matters in all the matters where they have undergone. If it is not an offense, penetrative sexual offense in POCSO case, small matters, section 6, 8, and 10 and all, if they have undergone more than a year, it should grant them. Forget about it. Yes. 75 days. 75. Yes.
75. Please, Your Lordship, the 2 years conviction, Your Lordship last time directed me to verify whether the petitioner has in custody or not. Minus paragraph 4, I have stated that on the day of surrender, you have the revision.
That day you didn't say.
Last.
I was.
Sorry, last. Yeah.
Yes. What was the case? Let us see. Sentence is
2 years.
2 years. You have undergone about?
No, not honorable.
Not know.
The day of surrender, 12 of
Section 12 POCSO.
Yes, madam. Informant appear and they.
Yes. What do you say? No objection. You have no objection. Petitioner, the appellant has been convicted for offence under section 12 of POCSO Act and sentenced to undergo RI for?
Time.
What is the sentence?
Sentence 2 years, my lord.
2 years.
43. Page 43.
Yes, 2 years. No fine, huh?
No.
Correct. 2 years.
Only 2 years.
2 years. The
Yeah, 2000 fine, sir.
appeal.
2000 fine.
Huh?
Period of 2 years and to pay fine 2000. In default, you got imprisonment for 2 months.
So the appeal has already been admitted on 26/11/2025. Notice was issued to the victim public, the informant, pursuant to the service of notice shown to enter appearance, and submits that he has instructed not to oppose the bill, not to oppose the bill. Regarding it to the nature of custody period, you have not undergone anything. The petitioner is in custody after the judgment judgment of conviction was passed on. No, you were already on bail, na?
Okay.
It is only for suspension of sentence now. After conviction on 13th November 2025, you are in custody.
No, ma'am.
No.
Interim bail granted.
Interim bail.
Yes.
After the conviction recorded on 13 November 2025, the petitioner has also been granted interim bail. Interim bail. Regarding the appeal form for
Yes.
yes, granted.
Bail melder. Bail allowed.
But there is no opposition. He says no opposition.
Yep.
Victim doesn't say yes. Okay.
Pass over item 1.
Yes. Oh, that's 145. I'll pass the order.
145, that 90 matter.
Oh, pass the order. Huh? Give. Yes.
Yeah, now the 11 order is under challenge.
Item 16.
Vigilance Council hasn't come, let's wait.
Pass over.
21.
Notice it. 21. Yes. Yes.
This matter arising out of a complaint case matter. Arising out of a complaint. Complaint is having the dispute that the complainant has paid some money to the present petitioner. And in the event of non-refunding of the same, the complainant approached the police. Police said that this is civil dispute will take place of remedy available under law. So thereafter, this complaint is filed. On the face of the record also, no criminal offense is made out. I have annexed the 202 statement. As well as
What are you seeking for quashing?
quashing of the cognizance and proceeding.
Yes. Yes.
I have made the complainant as the party.
What are the allegations? Let us see. What are the allegations?
May I read the 202 statement of the complainant so that
Tell me what are the allegations?
allegation minor the complainant had paid sum of rupees all total 10 lakh to the petitioners for the purpose of getting a piece of land. So that the petitioner will register a piece of land. Thereafter, it is alleged that the petitioners the complainant sent a legal notice demanding money. And when the money was not paid, now she filed the complaint.
What about, is there an agreement? Is there an agreement?
No, ma'am.
No agreement.
No. That is I am saying on the basis of the
What is your case?
Ma'am?
What is your case?
My case. My case is that
You are not taking money.
No, money has been taken. The amount which she is alleging that I have taken 10 lakh, but in fact 2 lakh were taken, and that 2 lakh has been refunded in the meantime. But she is making allegation that in cash she had paid sum of rupees 6.5 lakhs.
Okay. But I'll simply issue notice, let us see. Issue notice to opposite party number 2. Let us see. Yes. We'll file the process. Yes. Next.
There is an IM.
No stay. You have taken the money, unnecessary, your technical plea. You pay the money, whatever you have taken.
But that is why
Immediately, whatever you have taken.
if your
You take out notice, I'll just see. No stay.
in the event of our appearance, the matter may be referred to the mediation so that
Let him come. That's what I'm saying. You take out the notice. I'll fix it on 14th. Not 14th, 21st. Take out the notice. I'll try to settle it out. Yes, next.
in the meantime, adjournment petition.
Nothing will happen. Yes.
The charge for the
Yes, next. I can.
22. Yes, please, Your Lordship. My lord, due to it is a matter of compromise between both the parties, my lord. Both were not able to be present today, my lord. I thought it may be granted for the same.
When do you want?
My lord, 10 days.
The wait order dated 29/7/2026. Parties were directed to appear before this court physically or through video conferencing mode. Mode has it is stated in the bar that the dispute is arising up out of matrimonial discord and the parties have settled that dispute. Letter counsel for the parties submits that the petitioner and the private opposite party is not available. Hence, release the matter on 25th. 25th. Yes. 25th. Yes.
23.
23 also
same matter, my lord.
23 also same. Both the matters. Release both the matters. Yes.
37.
7 years.
Out of 10 years, minor situation in custody for 4-year carrying of manner.
Yes.
For the offense under section 376 2N and 506. Here in this case, after the petition case, the victim stated that the present petitioner.
Let me get the custody certificate. No? Custody certificate antecedent and release it in first, second week. Yes. Yes, next.
48. Section 366, 376 2N. Because case of consensual relationship, both victim and the appellant, they went fled away. They remained
different places are listed in Hyderabad. My lord, the victim's evidence.
POXO is also there.
POXO is
POXO.
Notice has been notice issue.
Notice is, but also appeared.
Notice is there. But
Appeared, already appeared.
Already
appeared. And we're supposed to file objection.
Council are very.
Objection. Who is appearing? No objection has been filed.
That victim who is more than 17 years, 1 month at the time of occurrence.
Now let us give last opportunity by the order dated 24 to 2025. The victim the informant was directed to file objection, if any, in terms of judgment of the Honorable Supreme Court reported in 2009 SSC 177 Atul Tripathi versus State of Uttar Pradesh and others. But the objection has not yet been filed, and then also non-appeals for the respondent informant. By way of the last and final opportunity, 2 weeks time granted to the informant of this victim to file the objection and lease the matter on 3rd of September. 3rd September, yes.
54.
part this matter and so also.
My lordship, my senior rightly point out that there is no role of the husband, but except PWA, it is an independent.
14. Yes.
I know Suresh Katoi, informant of the case. I know Mrs. Sandhita. She was married to Ramachandra and Bhartika Iria.
Mediator in the marriage and so on so. At the time of marriage, gold, silver ornament so on so had been given. Demand from the side of the bridegroom. Whether he has demanded, he tortured, where is that?
She is saying that his husband has tortured.
Where is that?
In the third cross-examination. Suresh Sato is not my co-religion nor relation. Ramachandra Pani and his parents are not my relation and co-religion. Once on the day of marriage, I had been to the house of Ramachandra Pani. I had not taken any money to that prior to the marriage. I was going to.
That is
After marriage, I have not.
nothing else.
Where is that? Where is that?
10 days also.
Be sure which.
Yes, ma'am.
It was
Yes.
the in-laws.
It will 10.
Then torture by her in-laws.
And everyone involves her in-laws.
In-laws, husband, mother-in-law, father-in-law granted bail.
Yes, ma'am.
Then
That
I will allow it. Yes. Yes.
Complaint.
Yes, next.
6. Vigilance House. 16.
Yes, vigilance. Yes, 16.
I think
Yes.
16.
16. Yes, Mr. Das. 16. Yes. Yes.
That as I said that he would reply.
And you are supposed to reply, it seems.
Yes. I think refresh it. Refresh the back.
The petitioner here with us is known as an co-accused in the charge sheet which I have annexed.
Yes.
Page 34 also.
Yes.
Page 39.
39.
35.
Yes.
Srimati Mimi Sahu is shown as accused charge sheeted, named as wife of Ramamundu. And it is stated that she was forwarded to court on 13 included.
She herself is a teacher.
Yes.
That's what you said.
Yes.
And her income, what I recall, there are 2 properties or 3 properties. 4 properties
Total value of 4 lakhs.
and 4 lakhs, and they have
Yeah.
taken your income to be 17 lakhs or something of that sort. Yes. Yes, Mr. Das, you are supposed to reply. You say disproportionate asset up for the husband, and you include 4 property for the wife. Wife herself is a teacher. And in the charge sheet itself, you say that her income is about 17 lakh rupees during that check period. And the property is about 4 lakhs rupees. So you justify, see, her income is sufficient to acquire those 4 properties. Can you include those 4 property in the income of the husband and say that you are the abettor?
But I'm afraid
That is what
I'm afraid, my lord, how that can be tagged with the concept of abatement.
That's what I'm asking. That's what
My
I'm asking.
answer would be in negative notes. The reason being notes.
Do you have any independent from the charge sheet itself?
Yes.
Do you have any independent material to implicate this lady merely because she is having some property? She has her own income. And that income you have taken yourself to be 17 lakhs.
That is not enough to, my lords, to absolve him from the allegations of abatement, my lords. I will satisfy lordship. The lordship kindly permit me for 5 to 7 minutes. I will place few lines only about the anvils of law on which this concept.
The law is very clear. That's not an issue. I'm on law is very clear. You will show that once witnesses have been examined and all this thing.
No, right. I will go to further deeper. That the maintenance of this revision as late, my lords, is not maintainable because the entire, my lords, if I take my takeout for what my learned senior submitted, my lords, that this kind of she has her own income, and she has procured all this property out of her own income, and the black money or the ill-gotten money of her husband has never accepted by her. This factor of abatement is lacking, my lord. That's why he will be absolved, my lord. He will be let off, my lord. That is the essence of submission, my lord. But at the end of the day, my lord, we are dealing with a revision application where a order rejecting a discharge application is put to scrutiny, my lords. A discharge application is rejected, my lords. And my lords, before I place that discharge application was placed, and my lord, that was also considered in consonance with the material produced by the prosecution, that is the charge sheet, my lord. And it was found that, my lords, the materials collected by the prosecution, my lord, unerringly indicates the completion of petitioner, for which that rejection order was passed. And my humble submission that cannot be faulted with, my lords. Now, my lords, in this revision, my lords, the main thrust of my senior's argument is that this kindly reappreciate the materials produced by prosecution. What is that? The charge sheet and found out, my lord. The reappreciation of that particular appreciation made by the special court, my lord, has been prohibited and fabricated. I just placed one line, my lords, because anvils of law on which, my lord, my submission will be tested, my lord. I'll just place 2 lines only. The first judgment on which I bring to lordship, lordship is aware, that is 2018 volume 16 SCC 299, my lords. That now the entire revision.
Can you give me a copy of the?
Of course, my lord.
Yes.
I bought them like supply. My lord, the entire submission is that the charge sheet, which is a material produced by the prosecution at the stage of consideration of discharge application, was not properly considered. Kindly reappreciate this under the revision jurisdiction. But that is permissible. This is the 16th SCC 299 blocks.
How do you define appreciation?
Appreciation, appreciation means, I mean, a court has rightly, wrongly appreciated something.
No, what is appreciation according to you?
Suppose if the materials.
If there are 2 views are possible, or 3 views or multiple views are possible, then on the basis of appreciation, 1 view is picked up. That is appreciation.
That is possible.
But I am not on that.
Agreed.
What I am saying is, if it is apparently only 1 possible view is there, is it appreciation?
Agreed.
What my learned friend is trying to impress upon your lordship is that since the vigilance judge has acted as a post office, your lordship's hands are tied. I believe that's what.
I'm sorry, Mullah, I don't agree with you.
Lord, what I suggest, Lord, in clear case, the charge sheet is the end of that particular investigation. It was placed before it's a material placed by the prosecution, and that has to be considered. I mean, his application for decides to consider on the anvil of that particular charge sheet, Lord, and that was appreciated, Lord. And appreciated said found that the court found that there was materials which indicates his complicity, Lord, and discharge application rejected, Lord. Now, what is his mission? In the mission, in the revision of jurisdiction, this honorable High Court to reappreciate that particular because the special court.
No, that's what I'm asking. It is not a case of reappreciation. His case is not not a case of reappreciation. What he says is whatever charge sheet
it has not been appreciated in proper perspective. That is, he says at best.
No, I don't think he says that. He says that don't appreciate. Look at the charge sheet. If case is made out, it's all right. Case is not made out, I am discharged. That's what his case is.
Due to correction, his entire thing, if you can put in this word, he has appreciated, but in not proper perspective. I think he will agree with you. Anyway, my lord. At the end of the day, my lord, this my submission of this appreciation or reappreciation of that materials which was placed before the special courts for which this application rejected, culminating with that rejection order which is imputed, my lord, that has been prohibited. Why? In 2018-16, that's a judgment, my lord, where Supreme Court said, we declared the law to be the order framing charge is not only purely. I will also place the two judgment of this honorable courts on the same issue of abatement, my lord. Sorry, safe memo kouthila.
2018 kete kahile page taku n kahili I will also place this that.
Then I am sorry. ठीक है लिख लीजिए 324 page judgment is 2018. Lordship, refer I will get it back then lordship. Yes. Lordship, turn to the flag. I have put that flag only.
Yes.
My lord, 2018 volume 16.
Para 37.
Exactly. Yes. 2018 volume 16 SCC 299, my lords. Paragraph 37, my lords. Here also, my lord, 397 with the scope of the revision application was taken into consideration. What is the scope? Thus, we declared the law to be that or the framing of charge is not pure and interlocutory orders on the list. So skip that one, my lord. Let's turn to second line, my lords. My lord, the jurisdiction of High Court is not bad irrespective of the level of petition. Wait under 397 to 397, 482 CRPC and Article 227 Constitution. However, the line starts, the said jurisdiction is to be exercised consistent with the legislative policy to ensure expeditious disposal of trial without the same being in any manner hampered. Thus, consider the challenge to an order of charge. In this case, my lord, after rejection of this application, charge has been framed, 2 witnesses have been examined, my lords. The case has been posted to second 29. I'm sorry, posted to 2/9/2026, my lords. Here the charge has been framed, trials, comments, my lords.
Yes.
My lords, the challenge to an order of charge should be entertained in the rarest of rare cases. This case definitely doesn't follow the case, but I'm coming back to the omission. This is
only to correct the patent error of jurisdiction.
Suppose a order,
and not only appreciate the matter.
Order has been passed, order was passed by the commission. I understand these are the patent error of jurisdiction, but this is an order impugned which is culminated from a competent courts, my lords, and my lords, and not to reappreciate the matters. Under the revision jurisdiction, you'll also put him in that then if there is an appreciation by the London Special Court, whether all courts are divided in appreciating, yes, it is permission in the appeal forum. That is the reason, my lord, the Honorable Supreme Court's law in a case coming out from this case or in that abatement matter, the government carried the matter to Supreme Court. And Supreme Court said, suffice to observe that High Court, our High Court, has analyzed the matter as if it was deciding an appeal against conviction and also went to the note defects of investigation. This is not the scale on which discharge applications to dealt with.
Yes.
Reappreciation is permissible. I don't say that once special court has appreciated something that cannot be, other courts are hands are tied. No. What is the forum? Not the revision, definitely. It is the appellate forum. That's
conviction to sure
Yes, once a charge frame trial starts, it will end in a conviction or an acquittal. No question of dissent in the midst.
Yes.
This is another case of abatement, and I was considering that when I was assistant attorney, I was assisting the court, and I placed that matter. The honorable court, this honorable court passed the order that I will also place that particular judgment also, and we went to Supreme Court. Supreme Court passed the orders. This kind of appreciation is permissible in appellate authorities, not under the revision jurisdiction.
Yes. Yes.
No, don't say that place.
Yes.
I completed my first submission and coming to the second one. So reappreciation has been forbidden. Now I'm coming back to the scope of this particular view is not the sterilization. It has been consistently followed by the Honorable Supreme Court till today, my lord. In 2023 also, my lord, same standard has been followed. Lord, you can I place it. This was placed into service by me in another case, my lord. At the cost of I just placed 2 lines only, my lords. I will stick to my promise, my lords. I will not waste lordship time. Lordship it turns to the orange flags, my lord. The paragraph 979. Mine can note down. 2023 volume 6 SCC 768. 2023 volume 6 SCC 768, my lords. State of Tamil Nadu versus R. Sundar Raju. Let's return to paragraph 79. First, the revisional power cannot be exercised in a casual or mechanical manner. It can only be exercised to correct manifest errors of law, or the procedure cannot be equated with the appellate power. A revisional court cannot undertake meticulous examination of the materials on records.
The same principle. HN resurfacing. Same principle. Same principle.
Next page. That's it.
Principle is same. It is
the same.
Take a note of that.
That apart, one rider is that I'm placing it. Para 881 notes. This court in so and so, my lord, I have to repeat this one, pay 81. And the High Court should not say to have done the role of a chartered accountant. At the end of the day, what I am doing, I'm participating in a proceeding to calculate. This is the income, this is the expenditures, this thing has come from this source, that things have come from, it's nothing but what is this calculation can address kind of chartered accountants' works or accountants' work. You can put anything but amounts to calculation words. That has been prohibited. Because that is the domain, that is a subject to be decided in the trial. Because that opportunity is there to adduce cogent evidence to that. You can start, these are the calculations.
Where is my judgment in that matter? That what is the lady was discharged.
In that case, my lord, in that Surnalata matters, my lord, the distinguishable point in this and that particular case is not applicable here because in that case, your lordship held that if the wife of the principal accused doesn't put forth a separate defense to justify. Here is a case, my lord, with full force, my lords, coming up with a case. Look, I have got that own my income, my lords. I am sufficient, my lord. These are the things I've acquired by investing in own money, my lords. But in case of Sonalata, it's a poor, absolutely having a relationship with the husband, which can be constituted definitely as a prudential relationship. Husband won't diya to karenge. But this kind of relation, but what is this, my lord? This is the woman, my lord, coming up with a full-fledged showed, my lord. I have got income. I have purchased all this thing. My lord, this thing is lacking in Sonobada. That's the fact.
Therefore, you want to say that since she has put forth an independent defense, she has to prove it. That's what you are precisely saying.
The ratio in that place, and your lordship judgment was endorsed by the Honorable Supreme Court, my lords. I'm told I've got the copies also, my lord.
Yes.
Endorsed. And this is a unique thing. And Odisha High Court is ahead after your lordship judgment in that case, disciplinary proceeding and when somebody is let off automatically, the criminal proceeding. That was one of the lordship leading judgment. Subsequently, Supreme Court judgment came up, Lord, in Anil Kumar matters. And this is also a case, my lordship, this concept, because I'm in touch with all the judgment of Supreme Court. I was a part-time editor at High Court. But
that way you are trying to deceive.
This will not lend support to my learned faith summits. I'm sorry.
Yes, Mr. Pradhan. Now.
And will not, I have 2-3 minutes. Let him finish. No,
second point is
I place that particular concept of the scope of revision authority and the appellate.
These are the first principles. There is no.
Now, my lords, I'm coming to my lords. Now, the reappreciation or kindly, my lord, the learned special judge has not considered in proper perspective And this honorable court will look into, my lord. But that is primarily wrong because the law has been set into rest in the case of state of Tamil Nadu versus N. Suresh Dutt, 2014, volume 50. 21 blocks.
Yes. For what?
Let us
What is the principle?
My lords, with regard to just 2 lines only. It has to be accepted in total as true, my lords. If you want to review that thing, go to the times. But at the time,
Then whatever charge sheet you file, that should be treated as a gospel truth. No scrutiny.
No scrutiny.
Then where is the stage of cognizance, stage of charge? Everything is redundant.
If Lordship put the right question, then what is the scrutiny? Scrutiny is that is there any material which unequivocally indicates
That is what Mr. Ponda says. If you say she has 17 lakh rupee income and she has purchased only 4 lakhs rupees property, how would you say that this property belongs to the husband and prosecute him saying that you have evaded? That's the only distinction. It is only simple arithmetic. This accountancy, nothing is required.
This is one. And the second point is important.
If she would not have any income and 4 lakhs rupees property is purchased and she is putting forth a defense, then she has to face the trial and prove it. This 4 lakhs, where from you got it? Now she has 17 lakhs with him. With her.
I'll just mean what is the fact?
And 17 lakhs out of 17 lakhs.
I'm going to place the factum of abatement so far the petition has committed. I'm placing that one.
But merely writing one word abatement doesn't mean that he has to pay the trial. She herself is a government employee. Just imagine what will happen. He'll lose the job because of the conduct of the husband.
No, not conduct, my lord. My wife knows what I'm doing, my lords. This is a practical approach in a pragmatic manner. I can't say no, blood. How many?
If the wife doesn't prevent the husband from doing this activity, illegal activity, can it be treated to be abatement?
My lord,
negative abatement.
I'm just so to your lordship of the records. Here the petitioner has gone with his wife. The petitioner has gone with her husband, the main accused in a BA case, my lord, to a particular place where land was purchased by with the ill-gotten money of the husbands in the name.
Show me that evidence. Show me the 161 statement. Come there. Why are you going here and there? Come there.
No, I'm just.
Don't go by the first principles. First principles are there. Everybody knows. Jurisdiction of revisional court is limited. And all these things.
I'm conscious, ma'am.
The original stage, the court should not be acted as a chartered accountant, count all these things. All these things are there.
My anxiety is that I'm opposing a formidable opposition board. That's why I'm going one by one.
Okay, let us see the 161 stage.
Am I more formidable than Mr. Dan, who has been holding the post of standing counsel for years?
Both of you are, in the equal level.
No.
You are tasting my patience, that's all.
In fact, Sanjeev
Let us see the main, come to main point.
What is the factum of abatement?
Abatement. You show me any evidence of abatement which is part of the charge sheet, then he is out.
The Lordship may turn to page 53 notes.
53. Yes. 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 These are the list of the properties.
Yes.
Item 4, 5, 6, 9 and 10.
Ticket. Well, Lordship may turn to 9 first.
9. Okay.
The district sub-registered Bhavanipatna, district Kalandi, by this letter number 7/6/2023 conveyed that Simoti Minisau,
has purchased.
Minisau petitioner has purchased land measuring so and so in the name of Minisau. The letter was written by the sub-register. And my lord, that petitioner from your own income
is 1 lakh
petitioner, and the petitioner for lordship, it was correctly my learned friend said, he's a primary school teacher. And primary school teacher purchased that land from her own income. The lordship turned to 10, The district sub-register of Bhavani Patna conveyed that Srimati Sahu petitioner had purchased land so and so, my lord. Now, my lords, contrary to that, my lords, come to the top.
The IO had written a letter to the district sub-registrar. He has given information. He has purchased that. That is the
Lords, we now turn to the 4. Same page 4.
4. Yes.
Sub-register M. Rampur District Kalandi, Vidis letter number 51 dated 16/3/2023, conveyed that Sri Pranabandhu Sahu, main accused in a DA case, has purchased land. He transmitted the money. He gave the money. Plot number so and so. Plot number is important.
Yes. Pranabandhu Sahu has purchased in the name of minister.
Here the ill-gotten money flows, and here the petitioner accepted and will not kept.
And 5 also.
The key factor is kept in that illustration of that mamala. Let's return to the 5 words. 5 sub-registered.
Yes.
So and so, my lord,
Yes, Mr. Pandit. Now explain me this.
My answer to that is
Yes.
none of these sub-registrars can ever have established, my lords, what my learned friend is trying to do. Because they are writing replies to letters sent by the I.
That's part of must be record.
Yes, look, your lordship may look at the records. The letter must have been written in this form. That it has come to the notice of so and so.
IO might have written it and
Sahu has purchased in name of his wife. Please supply the particulars. So they have written.
let us see that letter.
Yes.
Let us see the letter. See that. If this is there, then he has to prove Pranabandhu Sahu has purchased in the name of Mini Sahu or Mini Sahu herself has purchased. That is the only difference. Yes.
Now, this entire charge sheet belongs, as my learned friend has been saying, it shows assets have been sold, incomes have been sold, and expenditure has also been sold. Now, while showing all these bills, kindly see what the IO writes with regard to Minisa. The lordship will look at page 66.
I have not finished my lord.
It's all right. Now I got.
Yes. By my kind.
Yes.
The lordship will look at page 66.
Yes. I'm there.
Pranabandhu during his service period from 22 January to 18/10/14 acquired and possessed immovable and movable assets to the tune of rupees 61 lakhs 55,184 in his name and in the name of his family members, incurred expenditure of rupees 40 lakhs 42,840.02 against income of 73 lakhs 28,419.30 from all known such sources.
39.15.
Here comes to 28,69,604.64, which is 39.15% of his total income. Investigation will prove that there is prima facie evidence against accused Pranabandhu being a government servant, possessed assets disproportionate to the tune of 28,69,604.64 to his legal explained, and his wife so and so also has indulged in this offense by creating many valuable assets in her name involved with criminal conspiracy with her husband. Hence proof that the accused Pranabandhu and his wife Mini have criminally misconducted and are liable to be prosecuted under section 13(2) read with 13(1) PC Act 88/109. There is oral and documentary evidence against that. Now, kindly see what they write. Please look at page 50.
Yes.
Brief facts of the case. The
Yes.
second paragraph. Investigation revealed that accused so and so hails from such and such.
Paste.
50, right? Brief facts of the case. The family background and the degree of the accused Pranabandhu, that is the husband. Education and service particulars kind of the okay. Go against the investigation as an under section 13 to read with 13(1)(e) is not shown here. Marital life with the marital life is a middle of the portion. He again married Mindi, daughter of Dhanna, of village Gajara in the year 96, who happens to be his sister-in-law, working as a primary teacher at Chautipadar, CPS under Nakla Block, District Parasi. Out of second wedlock, they have been blessed with so and so, a son and a daughter, and they are studying in such and such. Now, by the time, my lords, the marriage has taken place, I am already in service. And the marriage is in 1996, whereas the check period, my lords, is from 1982 till 2014. So, I am not liable for the period 1982 to 1996. Then, submission of IT returns they have taken into consideration.
Yes.
I am only placing so far as I am concerned. His wife, Mindi Sahu, has also been filing IT returns by PAN such and such, showing income from salary and house rent during the year 1213 to 1415 as reply received from income tax.
Prior to that, you were not filing income.
No.
Yes.
Property statement. Property statement re pahila. Second paragraph. In letter number 582 of the block education officer has intimated that Mindi Sahu, assistant teacher, has not submitted property statement to her competent authority during her service period, also not taken permission given intimation to competent authority to
You are
let
not
her
given,
house
yes.
on rent, and has not taken permission given intimation to her competent authority to carry out private business in her name or in the name of her family members. Now, where is the allegation, my lords, that there is a house in the name of Mindi Sahu, which she has...
No, but if you have purchased it from your income, under the service rule also, you are supposed to.
I am coming to that.
Rule 54 and all, you have to supply.
What the right is that I have not taken permission to carry out private business. Now, none of these are the allegations of the vigilance against me. There is no house in my name and no private business is being carried out by me.
No, prior to that, he says that regarding the acquisition of the property and property statement, you have also not intimated or not taken permission. And service
Submitted property statement.
it was required.
Submitted.
Rule 54.
I have not submitted a property statement.
Yes.
Now, my lords, as per their own charge sheet, when I married, if I was a teacher, my lords, is it not incumbent for that investigating officer to find out at the time of marriage what was my probable savings?
I think that is there, but
has he done that? He has not done that.
You both of you file a written note of submission. Overall, I got the idea. Overall,
Well, I have not finished. I'm just too late.
No, you are unnecessary giving first principles. I am not interested in first principles.
Coming back to the main point.
I got the entire idea about this.
With regards to Lord's, so far the main crush of the matter is abatement. I'll just place the latest judgment of Supreme Court on that point. And
the law is, nobody is going to dispute about law. Law is, these are the principle everybody.
My Lord, at least, Lordship, provide me at two minutes.
Yes.
Yes, ma'am. My Lords, the latest judgment of the Supreme Court on this particular line is tactical.
Which judgment you are talking about?
That it is something.
What does it say? Tell me the proposition, that's all. Tell me the proposition. What do you want?
The proposition is that, my lords, in this particular case of P. Santi, the ratio laid down in Nanama has been practically resurrected. And they followed it to the extent, to what extent? Your Lordship may kindly see this particular, I just put that paragraph 11 was. No, I mean,
Yes.
I'm giving that pencil mark, my lords. Lordship may
What
turn
is
to
the ratio?
ratio is, my lord. Yeah, Lordship turn to para 7, my lords. I just placed 2 lines, my lord.
Tell me the ratio.
Because the facts are akin to the case at hand, my lords. Para 7, Lordship got it, my lords?
Yes.
I put some stuff. The case the appellant is that the courts below have grossly erred in convicting of awaiting her husband, main accused in acquiring disproportionate than the check period, and that any property disproportionately purchased by her husband in her name, that was the issue, and this case also akin to that one. Purchased by the main accused husband in the name during the check period cannot be held to be disproportionate. But these are the please, my lord. Let's skip all those things, my lords. My lord, the statute provision has been incorporated. Let's turn to para 11, my lord. The law, Lordship got it, para 11, my lords. Para 11 says law laid down by this court in respect of offense under section 109. Read with section 13(1) of the 88 Act in P. Nalamma versus State, represented by the Inspector of Police, 1999, volume 6, SEC 559. Where this court considered this was considering, let me allow. This court was considered, I was provided 2 minutes time, I have to finish it. Was considering whether the appellant therein are liable for convicted awaiting the actual law. Though, my lord, you can skip of that para 12, my lord. Let me come to the relevant portion, which has been, my lord, underlined by the Honorable Supreme Court, my lord. That, my lord, the first is 4-person, including the, I hope you lordship it in the right time, that underlined. 4-person, including the public servant, decides to raise bulk amounts through bribery, and the remaining person prompt. Here, my lord, the offer comes from the other person who accepts, my lord. Now, the case at hand, my lord, fall in the second, last one. If a public person takes
These are on facts of the case, I understand, but no application of this.
Then, my lord, lordship,
It is regarding a non-public servant can be prosecuted under 109, that is the law. He said it can be. That's what he says. No relevance.
My last one page, page 53, which I placed before. Lordship can call page 53.
I read that judgment full.
No, not judgment, that the petition notes.
Yes.
Page 53 notes.
53, yes.
I placed item number 4 minutes.
4, 5, 6 I read.
Yes, 4, 5, 6. 3 matters, not only 3 matters. 3 matters, 3 lands who are purchased. C consciously accompanied the accused husband. And Lordship may turn to the another thing is also there, that in page 55, he went to the RTO office, to purchase a Honda, the RTO's home purchase Honda in the name of this mini South. Now, Lordship turn to the accounts, lords.
RTO office ru kiye kine?
Na ticket benefit koi do dekhiye.
Who went to the RTO office to purchase a Honda?
Lordship may turn to page 58, my lord.
Honda ki kya batiye koi?
Husband purchases a car, wife goes with the husband. How does it
this will boats, my lords. And my lord, if their wings are not clipped, my lord, that sends a bad message to the people around us. They are real avatar.
You file that note.
Adding fuel to the facts, my lord. Lords, page 58, my lord.
I got it. See, these are the matter, 2 minutes matter. I have spent about.
Got only one request to be. The letters of the sub-registers will be available with me. But the queries made by the
will
will not be available.
In the trial,
he has to produce those.
You produce those.
In the trial, my lords.
Who trial? You just give it.
Prohibited.
You just give it. Let us see what kind of letter.
The
part of the charge sheet.
Trial chali chhe data witness exam is learning.
Part of the charge sheet. Charge sheet has been filed. Just look into those.
No, he wants a paper who just produced in the court and the trial is commencing.
It is a part of charge sheet, sir. It is a part of charge sheet. Give it.
Charge sheet तो आप लोग analyze करते हो आपको. अच्छा तो विश्वास होने से trial ले देखिए.
Okay, next item. Judgment reserve. parties to file the requisition.
They pass on another judgment of Supreme Court.
I know the judgments.
Placing it and placing it. And being,
You give a written note of submission along with the judgments. Give the citations with paragraph. Next item.
Take back all the judgments. Well, I'm fine.
Next item. 76.
Judgment.
Yes.
But written notes, I need some time.
Yes, yes. I'm giving 2 weeks time. Yes.
29 days.
76
months.
Yes. 29 day in filing. Appeal.
condone है
76. Okay. Delay for the reason stated in the application. Delay is condoned. Appeal is admitted already.
Not question of admission and notice.
Call from the trial court record. And what is the sentence?
Sentence 20 years.
20 years 5,000. Notice with the
Yes. TCR not fault for me. TCR. Yes.
77.
September 3rd week. Yes, next.
78.
May I please, appearing through VC, my lords.
Yes.
Yes, my lord. Conviction under section 376 2L, my lords. My lords, am I audible?
You're not fully audible. Anyway.
My lords, conviction under section 376 2L, my lords, for 10 years, RI for 10 years, out of which, my lord, I have undergone 3 months as UTP, then 10 months after the judgment, my lords.
What is the offense?
376 2. 10 years 25.
Notice has not gone, huh?
Notice.
No, my lords, notice has not gone.
Notice
Issue notice, huh? What is the period undergone?
My lords, 10 months after the judgment.
Okay. During trial, you were on bail, huh?
During the trial, I was on bail.
Call for the report, or we can report. In the meantime, least after the report is issued. Yes. Next.
79.
Actually. Not on the question 326A of IPC.
326. Sentence?
326A.
Huh?
326A of IPC.
Yes.
During trial and after bailment. Custody 2 years for 3 months.
1 year, 1 year, 5 months. Custody.
During trial.
During trial. Thereafter, you are in custody.
Yes.
Yes, from October 25. Custody. Yes.
Delay on the Sarah Dinan.
Huh?
Delay.
It is already admitted? No. What's the delay condoned? Admit, call for TCR. Realization of I mean, so far as IU is concerned, call for the report. Call for the report. Please sit up in third week of September. Yes. Sorry? Yes, yes, I have done it. Yes.
80.
81 of the not notice POCSO is there.
Notice service here.
During this sub-item.
Yes. Service is. Huh? Who is appearing? Mr. Ponda, requisites have not filed. Additional copy is not given. Though notice dated that notice issued to the informant oblique the complaint victim. By the order dated 27/2/2026, would not be served as the requisites have not been filed by the appellant. By way of on the last opportunity, 1 week can be granted to file requisites for the purpose of serving the informant oblique victim. Lease the matter after 3 weeks.
Notice matter.
Yes. Notice requisites have not been filed. Additional copies not given. Yes.
81.
This matter you also have before yesterday. Also that have this matter before yesterday. That is the condition of 376. The also has also seen the evidence of the victim. As well as the doctor's evidence. Watching kindly see.
So you short time. Yes, you tell me. I've heard her already. Huh?
16 years, conviction, 10 years conviction.
Undergone, what is the period undergone?
Yes.
More than 2 years. Yes. Victim, who is victim? PW?
5.
5. See, PW 5. Let us see.
One.
81. 81. No, PW5 is Kishore Sa.
Then 12, 13. After this paragraph,
11.
paragraph 2, where in the chief he has paid shelter, he has been this. Senseless, thereafter, one of showing the knife, she has been kidnapped. In the working condition, paragraph 11, 12, 13.
RTCR तो लग जाइए अभी तो TCR आउट तो लगी देखो PW5 is some 128 to 24. You're talking about PW5. PW5 is someone, huh? Arun Karlan. Huh?
Wrong, perhaps upload.
That's what I'm just wondering.
But the wrong upload is it. It is the 20, 12 of 20, 12 of 20. It is 17 of 20.
But that day I heard from you. Who do they feel with that?
Paragraph 11.
The wrong upload is it.
On that day, your logic has seen that.
But now it is something else uploaded.
It takes a 17 of 40. It uploaded. In the it has to city case bar of 40.
Huh?
Here is the year of 5 is the 33 years.
That's what just 33 some Kishore Sa.
Male person.
Kishore Sa, some male person, 33-year-old.
Male person.
Now, on that day, your logic has
Something that day it was correct record was there. Today something else has come. If the Kishore Sa says that it is a murder case. It is a murder case. And you have the copies. Have you gone through?
सरकार ने मतलब जजमेंट करते हैं इमिग्रेशन दियो तो और मत आगे ये दियो तो बेल ते मन्ना करे नका तू आगे कैसे जा कर चल दी
Just check the record. Check the record, and please the right record. I will put it day after tomorrow. Let the record come. We don't know what is the evidence and all. But official record has to be seen. The other evidence has to be there. Other evidences, all the evidence is there. Doctor, everything. Doctor Bhagaji.
Copy उठा देख करने का नाम है इधर follow करने नहीं.
ଆପଣ ଗୋଟେ କପି କରନ୍ତୁ ଫଟୋକପି ଦେଇଦିଅନ୍ତୁ ତାକୁ ତାଙ୍କୁ ତ ଭାଇ ତାଙ୍କ ପାଖେ ବି ନାହିଁ ନା ଇଏ କଣ କରିବେ ଏଭିଡେନ୍ସ ତ ଥିବାକୁ ପଡିବ ଆପଣଙ୍କ ପାଖେ ଅଛି କୋର୍ଟରେ ପାଖେ ନାହିଁ ତାଙ୍କ ପାଖେ ନାହିଁ ତାଙ୍କ ପାଖେ ନାହିଁ କଣ କରିବେ ଡେ ଆଫ୍ଟର ଟୁମରୋ and make sure that the right record is there. It is some murder case record is there.
Murder case.
21 years.
No. The problem is the trial court record shows that it is criminal appeal 128 of 2004, but record is something else. Absolutely wrong. पता नहीं I read it from here. I read it from here only. When she argued, I read it from here. हमरो हार्ड कॉपी चाहिए हार्ड कॉपी पेपरलेस सिस्टम
The paperless then.
Call that can be my guy. Call that and ask him what is going on. One hearing is wasted unnecessary. Day after tomorrow. Day after tomorrow. Thank you. The other day it was, no, from record room nije podichi, she podailu nije podichi. I remember. And he was not ready. He was not ready, so therefore I thought young man. Young man, let him read. That's what I remember. He is very overconfident.
ସେ ଡରି ଯାଉଛନ୍ତି ସମସ୍ତେ ଡରି ଯାଉଛନ୍ତି
ମାନେ he speaks like that. He never.
ସେ କମ୍ପ୍ୟୁଟର ବି ଖରାପ ହେଇଗଲାଣି ସେ ମ୍ୟାଡମ
He speaks like that. Yes. But 82. 82.
Yeah. He was on bail all through. The alleged tolerances under section 304 part 2. He's been sentenced to 8 years. He's in custody since the date of judgment, which is 5 months, my lords, now. The court to my lords is already on bail. That matter is also attached to this particular. It is on board as well. He's been given the court to my lords on bail since 21/3/2022. This is a split up trial. My only concern because he's a government servant and he has never misutilized the liberties, my lord, granted to him.
Let us see what are the evidence.
My lord. Here, my lord, see, fact is like this. Because on the date of an obscurity, when the mother of the deceased, he wanted to have certain food, the accused persons, it is alleged they refused. And the deceased refused. So that is the reason there was a dispute between the accused and the deceased. Four of the accused persons were there, out of them 2 were juvenile. One is the connected appeal, the present appeal. It is alleged they pushed him, resulting which he fell. He fell, my lords, on 19th, and then he was not taken for medical treatment and otherwise. He passed away on the 23rd, but he was treated for complicated malaria, which is on record as well. And then, my lords, that is the only injury which is also been discussed.
Let's see the doctor.
My lords. Doctor, my lords, PW level.
Yes.
PW level, my lords.
Yes.
I'm placing my lords. The first paragraph itself on 21/1/16, my lords, is found.
When the incident taken place?
19/1/2016.
After 19/1. Then after 2 days.
4 days.
19, na?
19/1/2016.
21, 19, 2021. 3 days.
21.
My lords, yes.
21.
Yes, 21. 23 he passed. Yes, my lords. 23 passed.
No, 21 he was.
Is the death, my lord. 21 is the death. After 3 days. On 21/2016, I was working as so my lords will find him. I'm placing from the 4th line. He had history of fever from 1 day and altered state of delirium for the last 8 hours. He also had a history of fall on the floor 2 days back. He was in the state of fever and his vital signs were stable and plantar response was non-reactive. He was treated in favor of a complicated malaria with a suspicion of a stroke. Well, that goes on. Paragraph 4 by kindness. Paragraph 4, cross-examination. It is a fact that the attendants of the patients had not disclosed about any assault on the patient prior to 22/1/2016. It is a fact that the person may fall on the ground if suffered from complicated malaria. Then the next page, PW12, who is the first attending physician. The size of the injury is also been discussed. It is 2x4 on the back of the head. He has fallen in his own home.
Yes. So any eyewitness?
Yes, madam. PW 5, 6, 7, and 10.
Informant is there.
Who are the close family members? They are the eyewitnesses.
PW
5, 6, 7, and 10. Madam.
Read 5.
5 is the informant. Who is the father? The occurrence has taken place on 19/1/2016 night at about 11 p.m. In that night, at around 11 p.m., while my son Gulu Sethi was sleeping in our house in a room, locking the door of that room was inside. At that time, the accused Damru Sethi, present appellant,
being associated,
accompanied by Jagli Sethi, co-accused present the corrected matter, and others came to our house, knocked the door of the room wherein my son Gulu Sethi was sleeping, and called my son Gulu Sethi to come outside. Hearing the same, my son Gulu Sethi was woken up and came to the outside room, opening the door of that room. Thereafter, the accused Gulu and his associate Jagli Sethi and 2 others have abused him. Hearing the sound, I came to the outside and found that the accused Dambu Sethi, Jagli and 2 others were assaulting Gulu Sethi by giving fist blows, and accused Dambu Sethi and Jagli Sethi gave a forcible push to my son Gulu Sethi from his front side, by the result of which he, Gulu Sethi, on a broken cement electric pole facing upwards and the backside of his head caused hurt on the cement pole and became senseless. Well, the English is a little bit
Head injury.
Head injury. 2 into 4 inch manner, that is the injury. But fact remains, from 19th till 21st, he was never treated, and only on the 22nd it was disclosed that he was injured. My case is that I am a government servant. I am posted elsewhere. This is other people who are involved.
Anyway.
Alibi is there. It is of course disbelief, so I am not placing that. And madam, that goes on.
And other accused persons have already been granted.
Yes.
They're juveniles or what?
No, my lords, 2 of them are juveniles. They have been, and
Jagili, what about Jagili?
Jagili, my lords, the appeal is there. 1-8 is there on board as well, my lords.
He is a juvenile.
No, my lords.
Jagili is not.
Not a juvenile. 147 of 2000.
He has been granted bail.
He has been granted bail, my lords, by order dated.
Yes. How do you say?
21-3.
How do you distinguish the case of Jagili from Damburu? Both of them assaulted. Both of them pushed. Jagli has been granted bail.
But main push was by this,
main. See, both of them came outside and found that accused Damburu and Jagli both have pushed. Damburu and Jagli gave a forcible push blow to my son. And Jagli has got the bail. Obviously, he's entitled.
And he was on bail all through. The present applicant was on bail.
Jagli has been granted. The petitioner has been convicted by the court of contempt. Mrs. Naidu appealing for the appellant taken me to the evidence of PW 5, 6, and 7 and submitted that as per the allegation of the prosecution, the present appellant and the one Jagli has given a push to the deceased, as a result of which he had a fell down and got stuck in a broken cement electric pole facing towards the backside. The said allegation is found corroboration with the evidence of PW 12 and 13. Na? PW doctor is 12 and
PW 5 and PW 6.
no doctor PW
Doctor PW
11 and
11.
PW 11 in 12 in his evidence has stated as under para first 1 para 1. Mrs. Naidu further submits that the co-accused Jagli Shetty has also filed a separate appeal, being criminal appeal number 147 of 2020. Which order he has been granted bail?
21-3-2022.
21?
3-2022.
Right, order dated 21-3-2022. The coordinated bench of this court has already enlarged the said co-accused on bail. Inter alia recording as under para last paragraph referring to the evidence of the State Council, although opposed the grant of bail to the present appellant, but could not distinguish the case of the present appellant from that of the case of
Jagli was in custody for some period. That is only difference.
And it is also brought on record. It is also submitted by Mrs. Naidu that the petitioner, the appellant, is a government servant and has already undergone how much?
5 months, my lords.
About 5 months custody period. Regarding to period of custody, And since the court which has already been granted the bail, and I'm inclined to suspend the sentence. I want to suspend the bail. Yes.
83.
Many losses. This is conditional construction loss. So what you six and 1 and 4 losses.
Yes, notice was issued. Notice was issued.
Okay, notice.
Notice. Also is that issue notice. I think it has been admitted, na? Yes, admitted. Notice. Yes.
Notice has not been sought.
Okay, fine. Yes.
84.
No, service you sir. Yes. Yes.
84.
84. Yes. Non-APS in the interest of the yes.
So it's 6 POCSO is there.
84.
20 years.
84.
84.
Notice, huh? 84 notice for prevalence. One of the offenses is token. We sit up in the 4th week of last week of September. Yes. 85.
85.
Section 6 POCSO minus 7 delay.
Not admitted yet. Yes. Delay for how many days delay? 17 days. As reported by the reporter. Alone for the investigation in the application. Admits for potential. And since one of the offenses, so if you notice, that the stay realization point. Yes. We sit up to the yes.
86.
The accused is convicted under section 23, subsection 2C, 25 and 28 of the
Delay of 18 days. Delay of 18 days stands condoned for the reasons stated in the application. Admit for potential stay realization of fine, and insofar as the application bail is concerned, issue notice. Issue accept notice. We sit up. Yes. Apprehension.
88.
May I please, Your Lordship, my lord, I am appearing through BC, my lord. I am, my bill is not good, and I am at Barampur, my lord. Sir, I am so I let it come after 1 week, my lord, I pray.
Third week of September. Yes.
Oblige, my lord.
89.
89. None for the petitioner. What is the yes, who is appealing? There is a stay order of operating.
This case number is 1015.
What is he asking?
2012 for an application for
Cognizance order challenged in 2012 and stay is operating. By way of this petition, petitioner has challenged the order of cognizance dated, the order dated 22/12/2011 passed by the learned SCG in Bhubaneswar, taking cognizance of offences under section 294, 323, 506 and 34. By order dated 24/7/2021, while if you notice the proceeding arising out of 1 CC case number 2655 of 2011. Since then. When the matter is called for hearing today, none appear for the petitioner. In case it stands the same is discussed. Yes.
90. 98 will let it come some other day.
And in the sub item, I am.
The word
CBI.
brief, I couldn't trace the
CBI. What is this matter is about?
Yes, so far as I remember, a final report was filed. That final report remained pending, my lords. And ultimately, after several years, the special judge CBI has taken cognizance.
So much of
disagreeing with the final.
Okay.
I couldn't trace out the brief, my lords.
Okay, Mr.
But the
Pandit.
matter, your lordship, the matter is from 2019. And there is an interim order, your lordship.
Maybe.
So therefore, I'm giving a short date. He wants to reconstruct his file. He missed it. Mr. Ponda appearing for the petitioner submits that he has misplaced his file. Want to reconstruct the thing. Hence, he seeks 2 weeks accommodation for that purpose. Release the matter on 28th of August. Interim order to continue. Meantime,
Your lordship, last time, your lordship had given a fixed date. On
the
that date, the
28th, I'm giving fixed date. It will not be adjourned on that day.
But I may be permitted to
That's
take
what
copy.
that's what I'm saying. Meantime,
pen drive.
Mr. Ponda is permitted to obtain the soft copy of the entire record from this court. Yes.
Already my case, CBI has given the already.
It's all right, I'll think. Entry order to continue till 28th. Yes. Yes. Next.
91.
91, my lord. Lordship, sir, this matter. Your my lords, the petitioner is a soil conservation officer. Now, there were allegations that certain amounts which were paid as subsidies for my lords digging ponds. So these amounts were. Now, petitioner has no role in all these transactions, my lords. And my second point is, my lords, no sanction has also been taken insofar as the petitioner is concerned. And cognizance has been taken by the magistrate. We put an application for to discharge him, my lords, which was rejected. That's why we are before your lordships. The fact remains, my lords, if your lordship sees the why he has been implicated, he was never named in the FIR or further consequential my lords investigation. Why he has been implicated is Act 52. He was asked some questions.
52.
52, my lords.
Yes.
One Vakil my lords, they had gone to him and other officers to find out what has happened with the misappropriated money. So they went to him. They are alleging that he did not give any satisfactory reply. Can that be a cause for initiation of a criminal proceeding?
You have pointed out 51, page 51.
Page 50.
This is the statement of one of the
52.
52.
52. A statement of one Vakil Mahal, which is about 8 lines to 8 to 10 lines from the bottom.
Yes.
ସେ କୌଣସି ସନ୍ତୋଷଜନକ ଉତ୍ତର ଦେଇପାରିଲେ ନାହିଁ. They asked him about all these.
Let us see the charge sheet.
Yeah.
What charge sheet says about
Yes,
this.
sir.
Final charge sheet.
Yes, fathers. It's a cryptic charge sheet.
What is your name? Your name is Satyanarayan. Okay.
That's at page 44.
44.
Brief facts of the case.
Yes. How many accused are there? Totally?
Including me, there are various accused persons. But in so far as this person is concerned, 2 points, my lords, no sanction. Second point is, my lords, what is the material against?
Let us see. What
Yes, my lord, your lordship has seen the charge sheet. But I showed your lordship the statement which is against me. They went to inquire about all these things, my lords. Santosh Janaka reply they parle. That is the material against him. Page 44. On 1/2/2008 at about 2 p.m.
No, second paragraph. During the
Second
investigation,
paragraph.
what?
During investigation, he visited, examined witness. 420, 467, 468, 34 made out against the accused persons. The accused persons, Srivaksa Meher, Prasanta Meher, both are village. This Vishwamitra Road, Raut, son of Kanika Raut of Tenta
And Satyanarayan.
Satyanarayan Achari. This person is Satyanarayan Achari, wife of Sanjeev, son of Sanjeev Achari, JSCO.
They don't say anything. They don't say anything.
Well arrested. Exactly.
They were arrested and.
The prima facie evidence was found against them and hence they were arrested.
Yes, what is there?
That is the order of discharge and revision will lie. That is it is not a maintainable because the revision is a lie. We can move before the concerned court.
Against?
My lord, that my lordship has gone to prayer of the petitioner, my lord.
Yes.
Call for the LCR and after the hearing the party ordered it such and such passed by the Learned Resident Patnagad.
Challenging the cognizance order.
Rejecting the discharge petition dated 24/11/21 and specified the petition of discharge from omission and allege of the offence prior to the entire criminal proceeding. There are multiple prayer is there, discharge petition and criminal proceeding.
By the way, there is no stay operating in this case.
Yes.
What happened to the trial?
So we can take
Discharge application is rejected.
No charges. No charges have been framed till date. Well, on this ground,
2021. What is happening? 5 years. There is no stay. Trial might have been concluded by now.
well, it's 2008, not 2021. 2008. Well, on this ground.
No, your discharge application was rejected on 2021.
Yes, Father.
So thereafter also about 5 years.
No charges,
5 years.
nothing has- And on this ground alone, my lords, this honorable court.
Yes, that can be a ground.
Vakil Singh has quashed the entire proceedings.
Yes, what do you say?
Yes, my lord. We can take the instruction whether what is the status of this case, my lord.
This case is arising out of a GR case number 39 of 2008. It appears that the discharge application moved by the petitioner has been rejected on 24/11/2021, which is under challenge before this court. From the proceedings of this court, it appears that there is no stay of trial court proceeding ever passed by this court. Therefore, by lapse of about 5 years from the date of rejection of discharge application, the trial might have proceeded substantially. However, Mr. Milan Kanwar, senior counsel appearing for petition submits that even charge has not yet been framed in this case. In view of the aforementioned, the state counsel is directed to seek instruction regarding the status of the trial by next date of hearing. Lease the matter on 21st of August. And meantime, which is the court? The registry is also directed to seek and report from SDGM or Patnagarh regarding the status of the trial, in which case pertaining to GR case number from
GR case number 39
of 2008.
of 2008.
39 of 2008. Okay.
Lordship imagines 2008, the empire is
So
lost.
we
Yes,
not
but
moving, then that itself is a
with
ground.
that it's your lordships have quashed a proceeding against the chief engineer. only
Even
on this-
482 can be exercised at this stage. Let us see.
Vakil Singh.
If you are not proceeding, then we'll see. Yes.
Okay.
92. Yes.
92, your lordships.
Yes.
I can't hear.
Mr. Jaydev, file is the adjournment.
Seeking an adjournment. Is there any stay
Your
operating?
lordship may kindly come to the stay order your lordships granted in the last date of hearing.
Made clear that the interim order for the proceeding is so and so pending in the court of progress.
Your lordships had Your
Till next
lordships,
date of hearing.
no,
There
your
is a
lordships,
stay order.
your lordship, this accused, your lordships, he confused the court. There are two accused, your lordships. One, Shivnarayan Das, as an independent person, is an accused. Shivnarayan Das, as a representative of the company, was also the accused. He said that, your lordships, under 3052 of the CRPC, the company will decide who will be the accused. But he got a stay order for himself, your lordship, not for the company. He tried to mislead the court, your lordships. If your lordships will see, the prayer.
You can otherwise proceed against him. The company is there.
Against the company, we can proceed, your lordships. If your lordships will
Represented by the same man.
So he is saying that I am not the representative. If your lordship will come to 3052 of the CRPC.
But junior counsel is seeking time.
But your lordship, they have been seeking time since 2022, your lordships, 5 years.
I'll give a short date by
tomorrow, your lordships.
Tomorrow not possible. Tomorrow not be possible.
Your lordship, this stay order may be vacated, your lordships.
On 12th.
But this order, your lordship may kindly come to the order, your lordship, for a moment.
But nothing will turn out because she's not even holding file.
Your lordship should not pass in an order. But this order, your lordships.
Why to waste 12th in any case, sir? I will hear you.
No further adjournment, your lordship may be.
No, it is made clear that no further adjournment on any pretext will be granted on that day. No adjournment, madam. I have recorded. In the event the petitioner would seek adjournment on the next date of hearing, this court will consider for vacating the interim stay granted earlier. Yes. I'll vacate the interim stay if next time you ask for adjournment. See, these are the matter 22. You have taken stay and you can't keep on asking adjournment. Yes. 93.
You also
27.
93 also, this is also not maintainable because of against the charge he come up. Revision is there.
The revision the discipline adjudicated notice has been issued, interim order has been passed. Last category will also be indicted counsel as amicus curiae for the victim and now if it is my friend that makes a technical objection, this can be converted to a revision and
You have been appointed.
My lord, I also concur to the submissions of the State Council. I have a judgment to that effect, which actually says that when a revision.
If I call, then they will justify. If I don't call, then there is no question of justification.
If you don't call, that doesn't mean that it will be ignored. If there is an objection, there has to be.
I'm only saying, no, I'm only saying that it.
482 is also maintainable. That's
Yes.
that may be.
But
482 is forbidden by this judgment.
My lord,
revision is maintainable. There is no.
My lord, in extreme cases that can be done, but my lord, their pleadings do not mention anywhere that it is an abuse of process of law or to prevent the ends of justice from getting defeated. They are approaching. Their simple prayer is, in simple terms, it is to set aside the discharge order which has been rejected. So that cannot be challenged in 482.
Sir, I just demonstrate factually how it is an abuse of process of court. My friend said it is not that I should write the language of 482 to prevent abuse of process of court for securing ends of justice. That language will not use. So actually, there must be a demonstration that the exercise of power under 482 will prevent abuse of process of court and secure ends of justice. So I will demonstrate from record. That's what I beg to demonstrate, nothing beyond that. How actually I am demonstrating, let me place. I know I have a two-prong attack from both the IPS Curiae and the head counsel. So I'll just show to your lordship. से जने constable तो एक पिलाटे को देखिले जे पिलाटी अत्यधिक पड़ी थी और लordship CDF है page 10.
Yes.
दीदी FIR लॉस पाए ये जो जमादार पुलिस है से ଗୋଟେ ପିଲାକୁ ଦେଖିଲେ ଅଚେତ ଅବସ୍ଥାରେ ପଡ଼ିଛି ତାକୁ ରେସ୍କ୍ୟୁ କଲା ପରେ ପଚାରିଲା ପରେ ସିଏ କ'ଣ କହିଲେ ସେଟାକୁ ସେ ଏଫଆଇଆର ମେନସନ କରୁଛନ୍ତି ମୁଁ ଟିକେ ସେଇ ତଳ ଲୋୟର ପୋର୍ସନ ଆଡକୁ
ପଳଉଛି
ତାର ମାଲିକ ଯଦିଓ କୌଣସି ପ୍ରକାର ଏଟା ଭିକ୍ଟିମ୍ କହୁଛି
ଶାରୀରିକ ନିର୍ଯାତନା ଦେଇନଥିଲେ କିନ୍ତୁ ତାର
ମାଲିକାଣୀ ଶ୍ରୀମତୀ ସନ୍ଧ୍ୟାରାଣୀ ସାମଲ पंचानन शामको उपस्थित 2 वर्ष हेलाଣି ଶାରୀରିକ ନିର୍ଯାତନା ଦେଇଥିଲେ ଏଇଟା କିଏ କହିଲେ ଇନଫର୍ମାଣ୍ଟ କହିଲେ ଦେନ୍ ଭିକ୍ଟିମ୍ ଷ୍ଟେଟମେଣ୍ଟ ଆଇ ହାଭ୍ annexed victim statement ଆପଣଙ୍କୁ ଟେରିଫ୍ କରିବି
Where is that? Yes, I got it. Read it.
ଆଜ୍ଞା ଟୁ ଦି ମିଡିଲ୍ କ୍ୱେଶ୍ଚନ୍ ଯଦିଓ ବାବୁ ପଞ୍ଚାନନ ସାମଲ ମତେ କେବେ ବି ପିଟାପରା କରିନାହାନ୍ତି କିନ୍ତୁ ବାବୁଆଣୀ ସନ୍ଧ୍ୟାରାଣୀ ବାବୁ ନଥିବା ସମୟରେ ବିଭିନ୍ନ ମାନେ ତାର ନିଜର ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ବାବୁ ନଥିବା ସମୟରେ ମାଲିକାଣୀ ମାନେ ମାଇ ଦି ୱାଇଫ୍ ଅଫ୍ petitioner number 1 used to harass her. Now we will come to the offense. First of all, my first submission is on the face of it.
Then on the basis of it, these two statements which you read, on the basis of that, then you don't want to press in so far the petition so far as petition number 2 is concerned.
Press କରୁଛି କଣଟା press
Why should you press? Then you will do, both of you will do.
ନା ଡୁମ୍ କରିବେନି କଣ ମୁଁ କହୁଛି ମୁଁ ପିଟିସନ ନମ୍ବର 2 କ ପାଇଁ ସବୁ ଅଫେନ୍ସ ପାଇଁ ପ୍ରେସ୍ କରିପାରିବିନି ଇଟ୍ସ ଏ କେସ୍ अगेंस्ट डिस्चार्ज सो ଗୋଟେ ଅଫେନ୍ସ ଯଦି ବିଲକୁଲ ହଉନଥିବ ସେ ଅଫେନ୍ସ ରୁ ମୁଁ ଡିସଚାର୍ଜ ହେବା ଉଚିତ ଦ୍ୟାଟ୍ ଇଜ ହ୍ୱାଟ ଆଇ ଗେଟ୍ ଟୁ ପଏଣ୍ଟ ଆଉଟ୍ ସୋ ଫାର ପିଟିସନ ନମ୍ବର 1 ଇଜ କନସର୍ନ he should not have been prosecuted on the teeth of the statement of the victim को जी किछि बाबू कर नाही बाबू नथिया अवस्था करछन
yes
तांको से लायबल कर दैछन now so far the other person is concerned 370 323 रहि पारे पाड़ा पिटा करथिले 34 रहबोनी कदी if your lordship intervenes
yes
subject to if your lordship intervenes so what is that
what are the charges now?
370 now your lordship may kindly see I'm sure my friends must not I don't want to embarrass them I'm actually I apologize to your lordship point and ମୁଁ କହିଲି ଆମେ ଯେତେବେଳେ honorable high court କୁ
At least you should carry
constitution high court rules এই চারটি মুখ্য বহি ଆମେ ସାଙ୍ଗରେ ନେଇକି ଆସିବା ଆମର କେସ୍ ଥାଉ ନଥାଉ
317
370 that's
yes
I'm placing
yes
370 is trafficking of persons
yes
exploitation includes so and so using force any other person so and so inducement
where from this boy came
man
where from this boy came to you this boy how the boy have come to you
it's a practice that is throughout the state
no you tell me what is the allegation you have, where from you got the boy who is victim where from you got this victim to your house court only said that is the question 370 is that is only 370 what else
ସେଇଟା ନାହିଁ କିଛି ନାହିଁ ସେଇଥିପାଇଁ ମୁଁ 370 ଟା କରିଥିବ ମୁଁ ପିଟିସନ ନମ୍ବର 2 କ କଥା କହୁଛି ଯେ ସେ 323 তে ରହିବ you are 323 transfer করতেন বিল আমি 370 I cannot take a plea that the discharge is 370 টা ରହିବନି ମୁଁ କହୁଛି now coming to the question how I have demonstrated the abuse of process of court or to secure ends of justice when apparently the victim herself says nothing like this petition number 1 definitely the continuance of the proceeding will be an abuse of process of court and that is what is my ground number 7 so therefore I have demonstrated factually not writing the language of 482 in essence so but demonstrating
no if you say at best 323 is made out against number 2
yes
at best
yes
then in that case 370 will also be made out
your lordship to decide
no that just see the provisions of law read the provision of law you whoever says recruit transport harbor transfer and receive a person you have recruited and torture so 370 is made out that will be a matter of trial
that your
that will be a matter of trial
that your lordship
what about the one
my lord actually
petition number 1
petition number
the victim himself says that in my absence
correct my lord
in the absence of this petitioner the wife Sandhyarani used to beat this is the
my lord
evidence
my lord to that effect
on the face of this evidence
yes my lord
at least one goes
no my lord one doesn't go why my lord because he's the one who recruited and he's the one who allowed that the victim will be subjected to cruelty he not recruited his wife could not have tortured
Where is that type of evidence he recruited?
My lord, because annexure 2, page 12 of their petition, my lord,
Yes.
that says, Mora Nama Madhusmita Singh, Pita Bhatta Singh, थाना बारिपदा आज ता एतिकी देख आपण ठारे मोर बयान एही कि जे बापा सबु बेले मद खाई बुलुथिवार एबर मो मां नथिवारु मु आजको प्राय 2 वर्ष हेबो तुलसी चौरार 55 सामलक घरे तांको घरे रहउछु. Now, even the charge sheet also reads that.
But who has recruited?
Charge sheet, my lord, reflects that. Charge sheet reflects that. That Panchanan Samal had recruited. My lord, if you see the page 20 of their petition, charge under section 370, 323, 34. There, in the second para, it is written. During course of investigation, I examined the complainant and other witnesses who well proved the occurrence, visited both the spot and prepared the spot map, issued injury requisition in respect of victim girl Madhusmita Singh, and sent her to DHH Baripada escort party with medical requisition for her examination and opinion. Accordingly, obtained the preliminary injury opinion report from the Dr. Nirmal Chandra Satpathy, who dictated 3 numbers of injury over the body of the victim, but reserved his opinion to be obtained from the surgical DHH Baripada. As prima facie evidence is well established under 373, 26, 34 and JJCPC 75 against the accused persons, namely Panchavan Samal and Sandhar.
Where is 164 statement?
This is the 164.
Let us see. Green fact is the summary of the IO. That one backed by yes, material.
What summary says?
IO summary.
IO says makes no
Panchavan Samal that is material is how.
Panchavan Samal এবং
কে আইনছে বলি সে কোন আন
No, 164 it is there.
Yes,
পঞ্চানন
সামল এবং তার স্ত্রী
তোর স্ত্রী সন্ধ্যারানী সামল আসি ଆମ ଘରକୁ আসি মতে
ଦେଇଥିଲେ.
But
I don't think you will.
Annexure 2.
But 164 statement?
Yeah.
Then how will you get over 164 statement? No, that's at this stage I can't go into all this. At the discharge stage, 164 statement is there that you and your wife went and got that boy, that girl, and thereafter you yourself say that 323 is made out, then you have tortured, finished.
That your lordship will say I relied upon that statement.
I think you shouldn't press it. I will have to write everything, then it will prejudice.
Say, but not press. Your lordship may not assign every region, but your lordship may.
Oh, you better you withdraw file a revision. Better.
Convert to prayer.
Then
revision I can file full limitation actually. After making a prayer.
Section 14. I'll pass the order. 164 days ago.
ମୁଁ ଥରେ ଯେତେବେଳେ କହି ଯେ 482 ହେଇପାରିବ ତାପରେ ମୁଁ
I will end it in 482, no problem.
No.
I ended in 482.
ମୁଁ ବି କହିବି ଯେ since your lordship suggested
But on merit you don't have a case.
No, but it is if it is not.
No, it is not.
So I can
164 days ago.
Once I argued and your lordship takes a view, I will not say that it should be converted to revision.
No, the material has to be seen.
It will not be fair to say that.
Okay, thank you.
So I will not say.
Thank you. Okay.
My
Yes. 95.
My lord, 95, I am for the opposite party, ED. My lord, the matter has been freshly assigned to me. So I need some time to actually go through the file.
In that matter, my name may be deleted from the court.
Actually, I'll tell you, senior name should not be there in the cause list at all.
But no, my lord, I have already resigned from the panel of enforcement director, so my name will be deleted.
Okay, Mr. Gopal Agarwal, submit that you don't want to continue with the so you may be dropped. He has been engaged press to the whole speech engagement. Is the matter after 2 weeks? 2 weeks?
2 weeks, sir.
After 2 weeks, yeah.
Okay.
Yes. After 2 weeks. His name, Mr. Gopal Agarwal's name, deleted from the list, and his name should be also. Yes. Yes. 97.
That 96, my lord.
96 whatever.
Right. 96
96.
Manas Mahapatra mentioned in the morning.
Oh, there is Mr. Manas Mahapatra is not well. So,
Your Lordship has fixed a date?
I think I have to September. First week of September, second week of September.
No, but there is no interim order, my lord.
Therefore, second. You need little more time.
No, my lord. Second week, the matter can be disposed of, my lord.
Yes.
It's prolonging for a long time.
You are appearing for whom?
I am appearing for the opposite party, the wife.
Opposite party. Yes. Yes.
My lord, one thing, my lord, I hope there is no extension of any interim order because there is no interim order as
No, I have not said anything.
Grateful, my lord. Grateful, my lord.
Yes.
97. My lord, here, my lord, I am appealing for the opposite party number 2. Please have a glance. The last order, my lord.
Opposite party.
Your stay was-
Kapilesh Singh. You are from Kapilesh Singh?
Yes, ma'am.
Yes.
Stay was allowed on the ground of deposit of rupees 25,000. Till now, they have not deposited. On the last occasion, my lord,
When was the order first? 25,000. Yes.
Milord, I am appearing for my lord, senior counsel Kaviraj Pradhan. Sir, my lord senior out of station. Yeah.
You are senior, maybe out of station, but what happened to the order?
on the last occasion also,
25/6/2024, this order was passed.
I don't know about this case because I don't read this file and
my lord, he
So-
just do not want to pay the money. On the last date, my lord, he has said that
I'll vacate
he
this
settle
state.
it down.
I'll vacate this state.
Yes, ma'am.
I'll vacate this. If you have not deposited the amount.
sir,
See, the amount was directed to be deposited way back in the June 2024. We are at 26.
sir,
2 years.
And thereafter, my lord, once the matter has been gone to the Lok Adalat also, before your lordship, they have not come to the.
What is this? What is this matter law?
My lord, once you see, there is a check bounce of rupees 62,000 only. From they have challenged the cognizance order on the ground that the date of check bounce and the date of issuance of legal notice is barred by limitation.
No.
But my lord,
This petition is arising out of
Sir,
1 CC case number 21 of 2020.
Milord, please give me 2 days to
No,
adjourn.
2020. 1 minute. 2020. For release commission of offence under section 138 NI Act on the allegation of reason of check of amount rupees
62,000.
62,000. When the matter was taken up on 25/6/2024, the coordinate bench of this court passed the following order, para 7. It is brought to the notice of the court. Again, the matter was taken up on 27/7/2026. And the petitioner, the counsel for the petitioner, made a statement before this court that he is ready and willing to make good to the entire check amount by next date available. On that condition, the interim order passed on 25/6/2024 was extended. Today, when the matter is taken up, the counsel advocate is seeking adjournment. In view of the conduct of the petitioner in the present matter, I am not inclined to give any further indulgence. Hence, the CRLMC stands dismissed. Yes. Yes.
98.
Yes.
An application where I have filled the order of cognizance as well as the complaint petition on the ground that they have not added the company as an accused. It is arising out of a 138 proceeding. Phase 13 is the complaint case 1 CC and phase Page 18 is the check copy. I have added, the managing director has signed the check. So in view of the judgment as laid down by the Honorable Apex Court.
Anita Hada and all.
Anita Hada, and also subsequently a Lordship has also on many occasions held that if you have not.
Show me the 138 notice, 138B notice. And you read my recent judgment. Recently I passed the judgment 5 days back. 138 notice.
138 notice.
If it is given to the managing director.
Yes.
And even if the company is not made party, that is a curable defect. Therefore, 138 complaint is maintained. That is what I have passed it. A curable defect 319, he can invoke 319 and ask to implead company. Being a curable defect, it can be maintained. Whether that judgment
it's not a company. My lords may kindly see page 13 complaint petition. It's a proprietorship. They have given a name of proprietorship.
Oh, then you have a one.
Your lordship kindly see.
It's a totally different.
Kindly see annexure 1 page 13.
Managing director, public director,
name
proprietorship.
Name and address. Proprietor.
Which company?
Proprietor. Your lords kindly see. 2. Name and address of the accused person. Page 13, my lord. Annexure 1 complaint petition.
Yes.
Name and address of accused person. Mihir Kumar Ratha, proprietor, United Tech Engineering Private. They have given the farm name. It's a proprietorship farm, my lord.
And United Engineer Private Limited.
They have given a name of a like.
Where from you got this name?
And my lords, my kind.
This complaint, the case is initiated by the complainant. They have written it is a proprietor. I am a company. I have replied. I have added additional document. If my lord may kindly see, I have additional IA with which I have filed my reply. In that my letterhead pad is there. My CIN number is there. And if you kindly have a glance to my lord to the check, proprietor cannot have a managing director. While I have issued the check, there this signing authority is the managing director for the private limited company. My lord, kindly have a glance to annexure 3, page 18, my lord.
Yes.
Page. Yes.
It is clear from that check itself. The managing director has signed the check. How can a farm can have a managing director? They have written it as a proprietor, but I am a company. And my CIN number is there also. Kindly have a glance to flag.
No, so give 138B notice. Give the notice.
Notice at annexure 4, my lord. Page 19.
19, huh? Let us see. Let us read. Here also proprietor.
They have written.
And my lord, your lordship, kindly see his reply. He appeared before.
No, but what kind of notice is this? Just see, Mihir Kumar Ratho, proprietor,
yes,
and United Engineering Private Limited company.
What he has given me, accordingly, I have made it. And he appeared.
But while making some kind of brain has to be applied. These are legal notice written by a lawyer in a private limited company proprietor.
He was, he is in fact, your lordship, kindly see his 205 application. He appeared before the court. File 205, your lordship, kindly see 205 application.
But that
he has never said that it's a company, I am not. Your lordship, kindly see. Rather, he sought for exemption under section 205. Your lordship, kindly see the application, my lord.
You are the inherent defect in the particular case, my lord.
And even if, my lord, it's a company, I have mentioned the name of the company, and as per your lordship's judgment, I can implead him as also party. He has given a check of 68 lakhs, and now.
Why have you not done so far? It may be a curable defect.
Because the proceeding was stayed by this honorable court, so I could not.
My lord, if I beg to differ on that point, it is not an incurable defect in view of the judgment of this Anita Haddad. They have clearly stated that it is not a curable defect. In this language itself, they have stated it is an incurable defect. And recent judgment goes on to show that before cognizance they can amend that.
Where is your reply to the 138 notice?
That is the flag B manner. Flag B I
This
have
is the reply.
through IA I have filed.
Through IA.
My lord. Separate application through an interim application I have filed. Flag B page 7 may kindly see.
Reply.
Page 7. Flag B page 7 may
Flag B for Bombay.
my lord.
Yes.
This is my reply.
There you have the notice reply. Yes. What is the reply?
Yeah.
In the above of that the reply, my lord, kindly see, I have mentioned my CIN number.
Where?
The in page 7 may kindly.
Wherever you say that you are not a proprietorship form, you are a company or something other sort.
That specific denial is not there.
Then
I have denied.
Lord, if he could have mentioned in his reply, I could have immediately taken steps while filing complaint. He has not, at that time, he has not said.
The problem, Mr. Agrawal, is in the reply, if you see at the
Yes, my lord.
bottom.
Seal is there, my lord. Yes, my lord. And in the, my lord, in
the bottom of the reply, just see.
Yes.
Where is the seal?
Yes,
Just
my-
see.
Yes, my lord.
For
Seal is
United
there.
Engineer Private Limited.
Yes, my lord. Seal is there. My lord, there was no specific amendment that it's a company, it's not a proprietorship firm. So accordingly, I filed the complaint, my lord. And my lord, otherwise, my lord, while filing complaint, I could have filed making complaint.
Why have you not done? Therefore, the lawyers are there. It's not,
Lord, your lordship.
what kind of
Your lordship
lawyer?
knows the trial court problem.
Despite the seal is there.
Seal is there.
And
my lord.
Engineering Private Limited, you write proprietor, private limited company. What is this kind
I
of?
gave the notice as a proprietor.
And you have to face for it if this kind of lawyers are defending.
Lord, I gave the notice as a proprietor. He replied
See,
to
you
it
gave the notice as a proprietor, but what have you written? Proprietor
of so and so company.
Limited, private limited, and
So
proprietor.
and so proprietor I mentioned, my lord. And he has not said it's a company. I am not the proprietor.
But the fact remains, I have in my.
This is.
copy,
I don't think you
mentioned the
will.
CIN
You can defend. It is a very.
It's a, my lord,
difficult
technical.
case.
It's a technical defect, my lord. I have mentioned, in spite of company, I have mentioned proprietor. It's not that I have not mentioned the name of the. Simply, I should have said only Mihir Kumar Ratta. Then yes, my lord, he has a case. I have mentioned the name of the company also. Except director, I have mentioned proprietor. That is the only anomaly, my lord.
And having said, having you once you write, you therefore you had the knowledge that it is a private limited company.
My lord, actually,
Not that you don't have a knowledge.
No, in fact, my lord,
You had a knowledge that it is a private limited company.
he
Therefore, it is obligatory in part. See, if you had no knowledge, you would have given it to the managing director, then the situation would have been different.
in fact, he had a no knowledge. He was thinking he is the proprietor. That's why he issued the notice.
Who
as
was
proprietor.
thinking?
The petitioner, my lord.
What about the lawyer?
My lord, lawyer, I cannot blame the lawyer, my lord, your lordship.
Lawyer doesn't know what is the proprietorship form, what is a private limited company. In a private limited company,
Yes,
there will be a
lawyer has-
proprietor. Therefore, legal notice.
That's correct, my lord. For a lawyer mistake, my lord, a part. Yes, my lord. But my lord, I have mentioned the name of the company. If the name not mentioned, then I agree, my lord. Simply, I could have said Mihir Kumar Ratta, then, my lord, yes, he has a case. I have also mentioned.
In the complaint, what do you say?
Again, the same thing, proprietor.
Complaint, my lord, I have not said whether company or proprietor. I have not.
Therefore, the
Only
complaint is also
in the cost title, my lord, I have said. The accused gave me the check, that I have explained the detail. In the cost title, I have said only in place of, my lord, director or managing director, proprietor has been mentioned. Name of the company has been mentioned, my lord. At page 13, my lord, column 2. Mihir Kumar Ratta, proprietor. Except director, proprietor has been mentioned, my lord. And company name, United India, company name, address, everything has been mentioned, my lord.
if you come to page 16,
Yes, my lord.
the document relied upon by you,
Yes, my lord.
you have to read carefully. F, just see F.
Reply to legal notice.
No, read full.
F, my lord.
Reply to the legal notice dated 13/4/2023 by the accused through United Engineering Private Limited, dated so.
A lawyer has committed. A lawyer has committed.
So one mistake one can ignore. So many mistakes.
In the Milord, in the notice, he has not said though the seal is there, Milord, there is no specific averment that it's a company. I am not the proprietor of the farm. If he could have said, Milord, yes, I have no case, Milord. It's a lawyer, Mr. Milord, in spite of director, he has mentioned proprietor. If company name was not there, then Milord, yes, I have no case. Company name has been mentioned, Milord.
But company was not made part.
Company has not been made a party, and cognizance has also been not taken.
So how will you distinguish Anita Hada in this? Have you seen my judgment, recent judgment?
I have not. I watch it probably tomorrow.
I'll put it every 3 days back.
Yes, Lord.
On this line, there are two judgments. Facts are little different. I have distinguished the complaint. What is the averment taken in the complaint? In the other case, also I have said that since notice was given to the managing director, it is suffice for the purpose of company and it is a curable defense.
Here also, my lord, the person who is the...
You have to distinguish that
Yes,
in the judgment. Released it on 19th. Entry mode to continue.
May I be pardoned to make a mention, Lordship? Item number 94, both parties are present on VC.
Okay.
She mentioned that she would be available because of health issue. But
94 years.
I don't have the power in the case, I'm appearing.
It's all right. 94, huh? Is it matrimonial dispute?
No, Your Lordship. I am for the accused person. I was appointed as electric bill collector at the OP number 2's company.
What are the offenses?
The offenses are of sections 409, 467, 468 and 471.
Oh, then
Of IPC.
what is the stage?
I was accused. I have done overwriting.
No. What is the stage of the trial?
Stage. Charge sheet has already been filed in this case and the matter has been amicably.
What is the stage? Evidence is going on. 467, 471 is there.
my lord,
Do you have any idea what is the stage? Trial stage?
My lord, can take an
Claimed and
That,
MFC asked her to cognizance of the same.
my lord,
Yeah,
page
no,
18. Receive the CS against the accused such and such.
I'm just asking whether
cognizance of-
evidence has already been started.
no,
How do you know? Where from you got?
from the I am for the OPT.
Where from you know that the evidence has not been recorded so far?
Because I have taken instruction from my client, OP number 2. He said that he has not deposed any evidence.
He may not, but the other witnesses might have been examined by now. It is not matrimonial dispute. 467, 471, 420, everything is there. It is not just a simple case. Get the status of the case. If evidence has already been recorded, then it may be difficult. I'm just lease it on
The amount
27.
in question is just 28,000.
Whatever, 20, let it come on 24th. Meanwhile, just verify. 24th, lease the matter on 24th. Let the parties be present. Yes, through which, yes. And get their Aadhaar card and
We have that.
yes. Okay. Next time, yes. Next. Not now. Huh?
Leave the other.
Yes. Which one?
Last item 100.
100.
99 mediation failed.
Mediation failed.
Mediation failed argument.
99?
Yes, ma'am.
Yes, mediation failed.
I am the petitioner.
99.
Yes, ma'am.
What happened? This is what kind of dispute is this?
There is arising out of a matrimonial passing of the cognizance order in rare case. And the sole ground is that divorce has been allowed between the party and permanent alimony has been given. 125 proceeding initiated by the wife has been dismissed for non-proceeding. TV proceeding initiated by the wife has been dismissed for non-proceeding. Husband is a private doctor, my lord. Wife is also a doctorate in the lecturer, continuing as a lecturer in the synergy.
But why why have you not settled? What is the problem?
That is a different issue, madam. It's the GR case, a resident of the FIR mind. The date was fixed for tomorrow for the examination of the wife, my lord, who is the informant in this case.
See, everything is settled now. You have been given divorce. DV Act is gone. 125 is gone. Why are you after?
17, my lord.
16.
And
What is the problem with you now? Why don't you want to settle?
instruction, madam.
Let them be present in the court.
I could have
So unnecessary.
seen to mediation, they have not come to the mediation.
Okay, let them both the parties be present in the court.
Mediation report is there.
Mediation failed, but I want to just know. Everything is settled in life. Unnecessary. The life is after the life. Yes. What will you get out of it? Nothing is, unnecessary harassing someone. If you want some money, you tell, I'll ask.
I didn't want matter for enhancement of the
Everything will settle. Let him come.
mind.
What is the alimony awarded to you?
11 lakh.
11 lakhs. You are seeking enhancement.
She is now getting perhaps the UGC statement. He's
No,
a
my
lecturer,
lord.
senior
There,
lecturer.
pay something, otherwise you will go to jail. Pay something and finish it
I
up.
have already paid my 11 lakhs.
Little more, she must be expecting little more, therefore she is pursuing this. You pay something, this will be over.
Later on,
And you will get rid of the entire, Seek instruction, come, both of you appear. We will,
Not blackmailing. It's GH.
better that you should
Have some
get ready to pay something. How much you are expecting?
I accept that.
How much you are expecting? Tell us, let us.
Genuinely, sir, I don't know amount. I will record the instructions. madam.
Okay, you come with the instruction how much you want. I will put it to him. And in between we do something, that matter will be over, this will also be over. Okay, let the parties be present in the court next on this date appearing on, that is on 12th of this month. 12th
August.
12th August.
Some more time. perhaps.
Okay.
Perhaps he is saying.
Let it be on 18th, huh?
18th.
18th August, yes. 900.
Item 100.
Interim order is there.
Interim order will continue.
There is no interim order, madam.
Interim order, if any, will continue.
The interim order your lordship passed on 13/11/2020.
Interim order, if any, will continue.
It will, my lord. Consider time question, my lord. But the date was fixed for tomorrow, my lord, for deposition.
It's already, if any, I am saying. Why do you aggravate this situation? I don't know. If there is no stay, I will say it also. Because I want to settle the dispute. Forget it. I am not saying anything.
Interim order may be.
Interim order, if any, will continue.
13/11/2020.
I don't know last time whether it was there or not. Anyway, we'll see. Yes.
Item 100. The petitioners are seeking passing of the entire proceedings by law. Offences are under section 374, trafficking of person, 120B, and there is 360, kidnapping by law. And the very first day it came before the lordship wanted to know whether on this offense of 374 can be quashed on the basis of compromise, because considering the particular facts and circumstances of the case. Also, I am seeking passing on 2 grounds, on bail as well as on the ground of compromise.
374? Yes.
Lord's time, I will elaborate the facts of the case, my lord. And here, my lord, the petitioner, OP number 2, who is the informant, was first married to petitioner number 4, my lord. Thereafter, from the first marriage, she got a child. Thereafter, she separated from her first husband.
What are the charges you say? 374?
374, 120B, 363.
363.
Kidnapping.
Okay, kidnapping. Yes.
My OP number 2 is the informant. She first got married to petitioner number 4. Thereafter, she got separated from petitioner number 4 and got married to petitioner number.
Now what happened? You tell me.
The matter has been settled. The child that was born from the second marriage, after the birth of the child that was from the second marriage, the second husband got to know that the informant was earlier married to petitioner number 4. Then he got jealous, and out of anger he thought that if he will give the child to a childless person, this informant will leave him. So he arranged. He contacted the first husband.
Why are you bringing all these things? Now they settle, na?
The child has
three.
There is my last occasion, my lordship died on 29/7/26.
Yes.
Both the parties should be present.
Remain present. And 374 is only 1 year sentence prescribed.
And 370
Petitioner and opinion 2.
Subsection 4.
4.
Trafficking of person. 370 subsection 4.
70.
370.
Say 74 charge. 70 is dangerous.
My lord, that's why
70 is dangerous.
That is the reason your lordship wanted judgments on that. My lord.
70.
Now the facts are consequential to the case, my lord. My lord, after the birth of the child from the second marriage, the husband, the petition number 3, got to know that the informant was earlier married.
Where from I'll get all these things? They are your defense.
That's it. It is there.
First, yes. Translated copy you give, but the translation has to be incorporated.
Tomorrow in the first one.
And self-edited copies of the Aadhaar card and all. That lady is there. You ask the lady whether he has any. Because 164 she has already given. Affidavit she has already given. Even if you put them to trial, this will be no use. But just ask her privately whether everything is all right. Madam, ଆପଣ ଏପଟେ ଆସନ୍ତୁ।